Tax Code. NIRC Outline. Title I. Organization and function of the Bureau of Internal Revenue. Title Tax on Income. Title III. Estate and Donors Taxes. Title IV. Value-added tax. Title V. Other percentage taxes. Title VI. Excise taxes on certain goods. Title VII. Documentary stamp tax. Title VIII. Remedies. Title IX. Compliance requirements. Title X. Statutory offences and penalties. Title XI. Allotment of internal revenue. Title XII. Oversight Committee. Title XIII. Tax incentives. Title I. Organization and function of the Bureau of Internal Revenue as last amended by RA 10963. SEC 1. Title of a code. This code shall be known as the National Internal Revenue Code of 1997. SEC 2. Powers and duties of the Bureau of Internal Revenue. The Bureau of Internal Revenue shall be under the supervision and control of the Department of Finance, and its powers and duties shall comprehend the assessment and collection of all national internal revenue taxes, fees, and charges, and the enforcement of all forfeitures, penalties, and fines connected therewith, including the execution of judgments in all cases decided in its favor by the Court of Tax Appeals and the ordinary courts. The Bureau shall give effect to and administer the supervisory and police powers conferred to it by this code or other laws. SEC 3. Chief officials of the Bureau of Internal Revenue. The Bureau of Internal Revenue shall have a chief to be known as Commissioner of Internal Revenue, hereinafter referred to as the Commissioner, and 4 assistant chiefs to be known as Deputy Commissioners. SEC 4. Power of the Commissioner to interpret tax laws and to decide tax cases. The power to interpret the provisions of this code and other tax laws shall be under the exclusive and original jurisdiction of the Commissioner, subject to review by the Secretary of Finance. The power to decide disputed assessments, refunds of internal revenue taxes, fees or other charges, penalties imposed in relation thereto, or other matters arising under this code or other laws or portions thereof administered by the Bureau of Internal Revenue is vested in the Commissioner, subject to the exclusive appellate jurisdiction of the Court of Tax Appeals. SEC 5. Power of the Commissioner to obtain information, and to summon, examine, and take testimony of persons. In ascertaining the correctness of any return, or in making a return when none has been made, or in determining the liability of any person for any internal revenue tax, or in collecting any such liability, or in evaluating tax compliance, the Commissioner is authorized: A. To examine any book, paper, record, or other data which may be relevant or material to such inquiry. B. To obtain on a regular basis from any person other than the person whose internal revenue tax liability is subject to audit or investigation, or from any office or officer of the national and local governments, government agencies and instrumentalities, including the Banco Central NG Pilipinas and government-owned or controlled corporations, any information such as but not limited of costs and volume of production, receipts or sales and gross incomes of taxpayers, and the names, addresses, and financial statements of corporations, mutual fund companies, insurance companies, regional operating headquarters of multinational companies, joint accounts, associations, joint ventures of consortia and registered partnerships, and their members, provided that the Cooperative Development Authority shall submit to the Bureau a tax incentive report, which shall include information on the income tax, value-added tax, and other tax incentives availed by cooperatives registered and enjoying incentives under Republic Act No. 6938, as amended, provided, further, that the information submitted by the Cooperative Development Authority to the Bureau shall be submitted to the Department of Finance and shall be included in the database created under Republic Act No. 10708, otherwise known as the Tax Incentives Management and Transparency Act (TIMTA). C. To summon the person liable for tax or required to file a return, or any officer or employee of such person, or any person having possession, custody, or care of the books of accounts and other accounting records containing entries relating to the business of the person liable for tax, or any other person, to appear before the Commissioner or his duly authorized representative at a time and place specified in the summons, and to produce such books, papers, records, or other data, and to give testimony. D. To take such testimony of the person concerned, under oath, as may be relevant or material to such inquiry, and E. To cause revenue officers and employees to make a canvass from time to time of any revenue district or region and inquire after and concerning all persons therein who may be liable to pay any internal revenue tax, and all persons owning or having the care, management or possession of any objects with respect to which a tax is imposed. The provisions of the foregoing paragraphs notwithstanding, nothing in this section shall be construed as granting the Commissioner the authority to inquire into bank deposits other than as provided for in Section 6F of this Code. SEC 6. Power of the Commissioner to make assessments and prescribe additional requirements for tax administration and enforcement. A. Examination of return and determination of tax due. After a return has been filed as required under the provisions of this code, the Commissioner or his duly authorized representative may authorize the examination of any taxpayer and the assessment of the correct amount of tax. Notwithstanding any law requiring the prior authorization of any government agency or instrumentality provided, however, that failure to file a return shall not prevent the Commissioner from authorizing the examination of any taxpayer. The tax or any deficiency tax or assessed shall be paid upon notice and demand from the Commissioner or from his duly authorized representative. Any return, statement of declaration filed in any office authorized to receive the same shall not be withdrawn, provided that within 3 years from the date of such filing, the same may be modified, changed, or amended, provided, further, that no notice for audit or investigation of such return, statement, or declaration has in the meantime been actually served upon the taxpayer. B. Failure to submit required returns, statements, reports, and other documents. A report required by law as a basis for the assessment of any national internal revenue tax shall not be forthcoming within the time fixed by laws or rules and regulations, or when there is reason to believe that any such report is false, incomplete, or erroneous. The Commissioner shall assess the proper tax on the best evidence obtainable. In case a person fails to file a required return or other document at the time prescribed by law, or willfully or otherwise files a false or fraudulent return or other document, the Commissioner shall make or amend the return from his own knowledge and from such information as he can obtain through testimony or otherwise, which shall be prima facie correct and sufficient for all legal purposes. C. Authority to conduct inventory taking, surveillance, and to prescribe presumptive gross sales and receipts. The Commissioner may, at any time during the taxable year, order inventory taking of goods of any taxpayer as a basis for determining his internal revenue tax liabilities, or may place the business operations of any person, natural or juridical, under observation or surveillance if there is reason to believe that such person is not declaring his correct income, sales, or receipts for internal revenue tax purposes. The findings may be used as the basis for assessing the taxes for the other months or quarters of the same or different taxable years, and such assessment shall be deemed prima facie correct when it is found that a person has failed to issue receipts and invoices in violation of the requirements of sections 113 and 237 of this code, or when there is reason to believe that the books of accounts or other records do not correctly reflect the declarations made or to be made in a return required to be filed under the provisions of this code. The Commissioner, after taking into account the sales, receipts, income, or other taxable base of other persons engaged in similar businesses under similar situations or circumstances, or after considering other relevant information, may prescribe a minimum amount of such gross receipts, sales, and taxable base, and such amount so prescribed shall be prima facie correct for purposes of determining the internal revenue tax liabilities of such person. D. Authority to terminate taxable period. When it shall come to the knowledge of the Commissioner that a taxpayer is retiring from business subject to tax, or is intending to leave the Philippines, or to remove his property therefrom, or to hide or conceal his property, or is performing any act tending to obstruct the proceedings for the collection of the tax for the past or current quarter or year, or to render the same totally or partly ineffective unless such proceedings are begun immediately, the Commissioner shall declare the tax period of such taxpayer terminated at any time, and shall send the taxpayer a notice of such decision, together with a request for the immediate payment of the tax for the period so declared terminated, and the tax for the preceding year or quarter, or such portion thereof as may be unpaid. And said taxes shall be due and payable immediately, and shall be subject to all the penalties hereafter prescribed, unless paid within the time fixed in the demand made by the Commissioner. E. Authority of the Commissioner to prescribe real property values. The Commissioner is hereby authorized to divide the Philippines into different zones or areas, and shall, upon mandatory consultation with competent appraisers both from the private and public sectors, and with prior notice to affected taxpayers, determine the fair market value of real properties located in each zone or area, subject to automatic adjustment once every 3 years through rules and regulations issued by the Secretary of Finance based on the current Philippine valuation standards, provided that no adjustment in zonal valuation shall be valid unless published in a newspaper of general circulation in the province, city, or municipality concerned, or in the absence thereof, shall be posted in a provincial capital, city, or municipal hall, and in two other conspicuous public places therein, provided, further, that the basis of any valuation, including the records of consultations done, shall be public records open to the inquiry of any taxpayer. For purposes of computing any internal revenue tax, the value of the property shall be whichever is the higher of 1. The fair market value as determined by the Commissioner, or 2. The fair market value as shown in the schedule of values of the provincial and city assessors. F. Authority of the Commissioner to inquire into bank deposit accounts and other related information held by financial institutions, notwithstanding any contrary provision of Republic Act No. 1405, Republic Act No. 6426, otherwise known as the Foreign Currency Deposit Act of the Philippines, and other general or special laws. The Commissioner is hereby authorized to inquire into the bank deposits and other related information held by financial institutions of 1. A decedent to determine his gross estate, and 2. Any taxpayer who has filed an application for compromise of his tax liability under Section 204(a)(2) of this Code by reason of financial incapacity to pay his tax liability. In case a taxpayer files an application to compromise the payment of his tax liabilities on his claim that his financial position demonstrates a clear inability to pay the tax assessed, his application shall not be considered unless and until he waives in writing his privilege under Republic Act No. 1405, Republic Act No. 6426, otherwise known as the Foreign Currency Deposit Act of the Philippines, or under other general or special laws, and such waiver shall constitute the authority of the Commissioner to inquire into the bank deposits of the taxpayer. 3. A specific taxpayer or taxpayers subject of a request for the supply of tax information from a foreign tax authority pursuant to an international convention or agreement on tax matters to which the Philippines is a signatory or a party, if provided that the information obtained from the banks and other financial institutions may be used by the Bureau of Internal Revenue for tax assessment, verification, audit and enforcement purposes. In case of a request from a foreign tax authority for tax information held by banks and financial institutions, the exchange of information shall be done in a secure manner to ensure confidentiality thereof under such rules and regulations as may be promulgated by the Secretary of Finance upon recommendation of the Commissioner. The Commissioner shall provide a tax information obtained from banks and financial institutions pursuant to a convention or agreement upon request of the foreign tax authority when such requesting foreign tax authority has provided the following information to demonstrate the foreseeable relevance of the information to the request. A. The identity of the person under examination or investigation. B. A statement of the information being sought, including its nature and the form in which the said foreign tax authority prefers to receive the information from the Commissioner. C. The tax purpose for which the information is being sought. D. Grounds for believing that the information requested is held in the Philippines or is in the possession or control of a person within the jurisdiction of the Philippines. E. To the extent known, the name and address of any person believed to be in possession of the requested information. F. A statement that the request is in conformity with the law and administrative practices of the said foreign tax authority, such that if the requested information was within the jurisdiction of the said foreign tax authority, then it would be able to obtain the information under its laws or in the normal course of administrative practice, and that it is in conformity with the convention or international agreement, and G. A statement that the requesting foreign tax authority has exhausted all means available in its own territory to obtain the information, except those that would give rise to disproportionate difficulties. The Commissioner shall forward the information as promptly as possible to the requesting foreign tax authority. To ensure a prompt response, the Commissioner shall confirm receipt of a request in writing to the requesting tax authority and shall notify the latter of deficiencies in the request, if any, within 60 days from receipt of the request. If the Commissioner is unable to obtain and provide the information within 90 days from receipt of the request, due to obstacles encountered in furnishing the information or when the bank or financial institution refuses to furnish the information, he shall immediately inform the requesting tax authority of the same, explaining the nature of the obstacles encountered or the reasons for refusal. The term "the foreign tax authority," as used herein, shall refer to the tax authority or tax administration of the requesting state under the tax treaty or convention to which the Philippines is a signatory or a party of. G. Authority to accredit and register tax agents. The Commissioner shall accredit and register, based on their professional competence, integrity and moral fitness, individuals and general professional partnerships and their representatives who prepare and file tax returns, statements, reports, protests, and other papers with or who appear before the Bureau for Taxpayers within 120 days from January 1, 1998, the Commissioner shall create national and regional accreditation boards, the members of which shall serve for 3 years, and shall designate from among the senior officials of the Bureau 1 chairman and 2 members for each board, subject to such rules and regulations as the Secretary of Finance shall promulgate upon the recommendation of the Commissioner. Individuals and general professional partnerships and their representatives who are denied accreditation by the Commissioner and/or the national and regional accreditation boards may appeal such denial to the Secretary of Finance, who shall rule on the appeal within 60 days from receipt of such appeal. Failure of the Secretary of Finance to rule on the appeal within the prescribed period shall be deemed as approval of the application for accreditation of the appellant. H. Authority of the Commissioner to prescribe additional procedural or documentary requirements. The Commissioner may prescribe the manner of compliance with any documentary or procedural requirement in connection with the submission or preparation of financial statements accompanying the tax returns. SEC 7. Authority of the Commissioner to delegate power. The Commissioner may delegate the powers vested in him under the pertinent provisions of this Code to any or such subordinate officials with the rank equivalent to a division chief or higher, subject to such limitations and restrictions as may be imposed under rules and regulations to be promulgated by the Secretary of Finance upon recommendation of the Commissioner, provided, however, that the following powers of the Commissioner shall not be delegated. A. The power to recommend the promulgation of rules and regulations by the Secretary of Finance. B. The power to issue rulings of first impression or to reverse, revoke or modify any existing ruling of the Bureau. C. The power to compromise or abate under Sec. 204 A and B of this Code any tax liability, provided, however, that assessments issued by the regional offices involving basic deficiency taxes of 500,000 pesos (P. 500,000) or less and minor criminal violations, as may be determined by rules and regulations to be promulgated by the Secretary of Finance upon recommendation of the Commissioner, discovered by regional and district officials, may be compromised by a regional evaluation board which shall be composed of the regional director as chairman, the assistant regional director, the heads of the legal, assessment and collection divisions and the revenue district officer having jurisdiction over the taxpayer as members, and D. The power to assign or reassign internal revenue officers to establishments where articles subject to excise tax are produced or kept. SEC 8. Duty of the Commissioner to ensure the provision and distribution of forms, receipts, certificates, and appliances, and the acknowledgement of payment of taxes. A. Provision and distribution to proper officials. Any law to the contrary notwithstanding, it shall be the duty of the Commissioner, among other things, to prescribe, provide, and distribute to the proper officials the requisite licenses. Internal revenue stamps, unique, secure and non-removable identification markings, hereafter called unique identification markings, such as codes or stamps, be affixed to or form part of all unit packets and packages and any outside packaging of cigarettes and bottles of distilled spirits, labels and other forms, certificates, bonds, records, invoices, books, receipts, instruments, appliances and apparatus used in administering the laws falling within the jurisdiction of the Bureau. For this purpose, internal revenue stamps or other markings and labels shall be caused by the Commissioner to be printed with adequate security features. Internal revenue stamps, whether of a barcode or fuse on design, or other markings shall be firmly and conspicuously affixed or printed on each pack of cigars and cigarettes and bottles of distilled spirit subject to excise tax in the manner and form as prescribed by the Commissioner, upon approval of the Secretary of Finance. To further improve tax administration, cigarette and alcohol manufacturers shall be required to install automated volume counters of packs and bottles to deter over removals and misdeclaration of removals. B. Receipts for payment mode. It shall be the duty of the Commissioner or his duly authorized representative or an authorized agent bank to whom any payment of any tax is made under the provisions of this Code to acknowledge the payment of such tax, expressing the amount paid and the particular account for which such payment was made in a form and manner prescribed therefor by the Commissioner. SEC 9. Internal Revenue Districts. With the approval of the Secretary of Finance, the Commissioner shall divide the Philippines into such number of revenue districts as may from time to time be required for administrative purposes. Each of these districts shall be under the supervision of a revenue district officer. SEC 10. Revenue Regional Director. Under rules and regulations, policies and standards formulated by the Commissioner, with the approval of the Secretary of Finance, the Revenue Regional Director shall, within the region and district offices under his jurisdiction, among others, A. Implement laws, policies, plans, programs, rules and regulations of the department or agencies in the regional area. B. Administer and enforce internal revenue laws and rules and regulations, including the assessment and collection of all internal revenue taxes, charges and fees. C. Issue letters of authority for the examination of taxpayers within the region. D. Provide economical, efficient and effective service to the people in the area. E. Coordinate with regional offices or other departments, bureaus and agencies in the area. F. Coordinate with local government units in the area. G. Exercise control and supervision over the offices and employees within the region, and H. Perform such other functions as may be provided by law and as may be delegated by the Commissioner. SEC 11. Duties of revenue district officers and other internal revenue officers. It shall be the duty of every revenue district officer or other internal revenue officers and employees to ensure that all laws and rules and regulations affecting national internal revenue are faithfully executed and complied with, and to aid in the prevention, detection and punishment of frauds of delinquencies in connection therewith. It shall be the duty of every revenue district officer to examine the efficiency of all officers and employees of the Bureau of Internal Revenue under his supervision, and to report in writing to the Commissioner, through the Regional Director, any neglect of duty, incompetency, delinquency, or malfeasance in office of any internal revenue officer of which he may obtain knowledge, with a statement of all the facts and any evidence sustaining each case. SEC 12. Agents and deputies for collection of national internal revenue taxes. The following are hereby constituted agents of the Commissioner. A. The Commissioner of Customs and his subordinates with respect to the collection of national internal revenue taxes on imported goods. B. The head of the appropriate government office and his subordinates with respect to the collection of energy tax, and C. Banks duly accredited by the Commissioner with respect to receipt of payments internal revenue tax is authorized to be made through banks. Any officer or employee of an authorized agent bank assigned to receive internal revenue tax payments and transmit tax returns or documents to the Bureau of Internal Revenue shall be subject to the same sanctions and penalties prescribed in sections 269 and 270 of this code. SEC 13. Authority of a revenue officer. Subject to the rules and regulations to be prescribed by the Secretary of Finance upon recommendation of the Commissioner. A revenue officer assigned to perform assessment functions in any district may, pursuant to a letter of authority issued by the Revenue Regional Director, examine taxpayers within the jurisdiction of the district in order to collect the correct amount of tax, or to recommend the assessment of any deficiency tax due in the same manner that the said acts could have been performed by the Revenue Regional Director himself. SEC 14. Authority of officers to administer oaths and take testimony. The Commissioner, Deputy Commissioners, Service Chiefs, Assistant Service Chiefs, Revenue Regional Directors, Assistant Revenue Regional Directors, Chiefs and Assistant Chiefs of Divisions, Revenue District Officers, Special Deputies of the Commissioner, Internal Revenue Officers and any other employee of the Bureau thereunto especially deputized by the Commissioner shall have the power to administer oaths and to take testimony in any official matter or investigation conducted by them regarding matters within the jurisdiction of the Bureau. SEC 15. Authority of Internal Revenue Officers to make arrests and seizures. The Commissioner, the Deputy Commissioners, the Revenue Regional Directors, the Revenue District Officers and other Internal Revenue Officers shall have authority to make arrests and seizures for the violation of any penal law, rule or regulation administered by the Bureau of Internal Revenue. Any person so arrested shall be forthwith brought before a court there to be dealt with according to law. SEC 16. Assignment of internal revenue officers involved in excise tax functions to establishments where articles subject to excise tax are produced or kept. The Commissioner shall employ, assign, or reassign internal revenue officers involved in excise tax functions as often as the exigencies of the Revenue Service may require, to establishments or places where articles subject to excise tax are produced or kept, provided that an internal revenue officer assigned to any such establishment shall in no case stay in his assignment for more than 2 years. Subject to rules and regulations to be prescribed by the Secretary of Finance upon recommendation of the Commissioner. SEC 17. Assignment of internal revenue officers and other employees to other duties. The Commissioner may, subject to the provisions of Section 16 in the laws on civil service, as well as the rules and regulations to be prescribed by the Secretary of Finance upon the recommendation of the Commissioner, assign or reassign internal revenue officers and employees of the Bureau of Internal Revenue, without change in their official rank and salary, to other or special duties connected with the enforcement or administration of the revenue laws as the exigencies of the service may require, provided that internal revenue officers assigned to perform assessment or collection function shall not remain in the same assignment for more than 3 years, provided, further, that assignment of internal revenue officers and employees of the Bureau to special duties shall not exceed 1 year. SEC 18. Reports of violation of laws. When an internal revenue officer discovers evidence of a violation of this code or of any law, rule or regulations administered by the Bureau of Internal Revenue of such character as to warrant the institution of criminal proceedings, he shall immediately report the facts to the Commissioner through his immediate superior, giving the name and address of the offender and the names of the witnesses if possible, provided that in urgent cases, the Revenue Regional Director or Revenue District Officer, as the case may send the report to the corresponding prosecuting officer. In the latter case, a copy of his report shall be sent to the Commissioner. SEC 19. Contents of Commissioner's Annual Report. The annual report of the Commissioner shall contain detailed statements of the collections of the Bureau with specifications of the sources of revenue by type of tax, by manner of payment, by revenue region and by industry group, and its disbursements by classes of expenditures. In case the actual collection exceeds or falls short of target as set in the annual national budget by 15% or more, the Commissioner shall explain the reason for such excess or shortfall. SEC 20. Submission of report and pertinent information by the Commissioner. A. Submission of pertinent information to Congress. The provision of Section 270 of this code to the contrary notwithstanding, the Commissioner shall, upon request of Congress and in aid of legislation, furnish its appropriate committee pertinent information including but not limited to industry audits, collection performance data, status reports in criminal actions initiated against persons and taxpayers' returns, provided, however, that any return or return information which can be associated with or otherwise identify, directly or indirectly, a particular taxpayer shall be furnished the appropriate committee of Congress only when sitting in executive session unless such taxpayer otherwise consents in writing to such disclosure. B. Submission of tax-related information to the Department of Finance. The Commissioner shall, upon the order of the Secretary of Finance specifically identifying the needed information and justification for such order in relation to the grant of incentives under Title 13, furnish the Secretary pertinent information on the entities receiving incentives under this code, provided, however, that the Secretary and the relevant officers handling such specific information shall be covered by the provisions of Section 270 unless the taxpayer consents in writing to such disclosure. See Report to Oversight Committee. The Commissioner shall, with reference to Section 204 of this Code, submit to the Oversight Committee referred to in Section 290 hereof, through the Chairman of the Committee on Ways and Means of the Senate and House of Representatives, a report on the exercise of his powers pursuant to the said section, every six months of each calendar year. SEC 21. Sources of revenue. The following taxes, fees and charges are deemed to be national internal revenue taxes. A. Income tax. B. Estate and donors taxes. C. Value-added tax. D. Other percentage taxes. E. Excise taxes. F. Documentary stamp taxes. And G. Such other taxes as are or hereafter may be imposed and collected by the Bureau of Internal Revenue. Less than back to NIRC outline greater than. Title 2. Tax on income as amended by RA-NOS. 9,294, 9,337, 9,504, 10,021, 10,026, 10,653 and 10,963. Chapter I. Definitions. SEC 22. Definitions. Used in this title. A. The term person means an individual, a trust, a state or corporation. B. The term corporation shall include one-person corporations, partnerships, no matter how created or organized, joint stock companies, joint accounts, cuentas en participación, polo associations, or insurance companies, but does not include general professional partnerships and a joint venture or consortium formed for the purpose of undertaking construction projects or engaging in petroleum, coal, geothermal and other energy operations pursuant to an operating consortium agreement under a service contract with the government. General professional partnerships are partnerships formed by persons for the sole purpose of exercising their common profession, no part of the income of which is derived from engaging in any trade or business. C. The term domestic, when applied to a corporation, means created or organized in the Philippines or under its laws. D. The term foreign, when applied to a corporation, means a corporation which is not domestic. E. The term non-resident citizen means 1. A citizen of the Philippines who establishes to the satisfaction of the Commissioner the fact of his physical presence abroad with a definite intention to reside therein. 2. A citizen of the Philippines who leaves the Philippines during the taxable year to reside abroad, either as an immigrant or for employment on a permanent basis. 3. A citizen of the Philippines who works and derives income from abroad and whose employment thereat requires him to be physically present abroad most of the time during the taxable year. 4. A citizen who has been previously considered as a non-resident citizen and who arrives in the Philippines at any time during the taxable year to reside permanently in the Philippines shall likewise be treated as a non-resident citizen for the taxable year in which he arrives in the Philippines with respect to his income derived from sources abroad until the date of his arrival in the Philippines. 5. The taxpayer shall submit proof to the Commissioner to show his intention of leaving the Philippines to reside permanently abroad or to return to and reside in the Philippines as the case may be for purpose of this section. F. The term resident alien means an individual whose residence is within the Philippines and who is not a citizen thereof. G. The term non-resident alien means an individual whose residence is not within the Philippines and who is not a citizen thereof. H. The term resident foreign corporation applies to a foreign corporation engaged in trade or business within the Philippines. I. The term non-resident foreign corporation applies to a foreign corporation not engaged in trade or business within the Philippines. J. The term fiduciary means a guardian, trustee, executor, administrator, receiver, conservator or any person acting in any fiduciary capacity for any person. K. The term withholding agent means any person required to deduct and withhold any tax under the provisions of Section 57. L. The term shares of stock shall include shares of stock of a corporation, warrants and/or options to purchase shares of stock, as well as units of participation in a partnership except general professional partnerships, joint stock companies, joint accounts, joint ventures taxable as corporations, associations and recreation or amusement clubs, such as golf, polo or similar clubs, and mutual fund certificates. M. The term shareholders will include holders of a share, S of stock, warrant, S and/or option, S to purchase shares of stock of a corporation, as well as a holder of a unit of participation in a partnership except general professional partnerships in a joint stock company, a joint account, a taxable joint venture, a member of an association, recreation or amusement club, such as golf, polo or similar clubs, and a holder of a mutual fund certificate, a member in an association, joint stock company, or insurance company. N. The term taxpayer means any person subject to tax imposed by this title. O. The terms including and includes, when used in a definition contained in this title, shall not be deemed to exclude other things otherwise within the meaning of the term defined. P. The term taxable year means the calendar year or the fiscal year ending during such calendar year upon the basis of which the net income is computed under this title. Taxable year includes, in the case of a return made for a fractional part of a year under the provisions of this title or under rules and regulations prescribed by the Secretary of Finance, upon recommendation of the Commissioner, the period for which such return is made. Q. The term fiscal year means an accounting period of 12 months ending on the last day of any month other than December. R. The terms paid or incurred and paid or accrued shall be construed according to the method of accounting upon the basis of which the net income is computed under this title. S. The term trade or business includes the performance of the functions of a public office. T. The term securities means shares of stock in a corporation and rights to subscribe for or to receive such shares. The term includes bonds, debentures, notes or certificates, or other evidence or indebtedness issued by any corporation, including those issued by a government or political subdivision thereof, with interest coupons or in registered form. U. The term dealer in securities means a merchant of stocks or securities, whether an individual, partnership or corporation, with an established place of business, regularly engaged in the purchase of securities and the resale thereof to customers, that is, one who, as a merchant, buys securities and resells them to customers with a view to the gains and profits that may be derived therefrom. V. The term bank means every banking institution, as defined in Section 2 of Republic Act No. 337, as amended, otherwise known as the General Banking Act. A bank may either be a commercial bank, a thrift bank, a development bank, a rural bank, or specialized government bank. W. The term non-bank financial intermediary means a financial intermediary, as defined in Section 2(d)(c) of Republic Act No. 337, as amended, otherwise known as the General Banking Act, authorized by the Banco Central ng Pilipinas (BSP) to perform quasi-banking activities. X. The term quasi-banking activities means borrowing funds from 20 or more personal or corporate lenders at any one time, through the issuance, endorsement, or acceptance of debt instruments of any kind other than deposits for the borrower's own account, or through the issuance of certificates of assignment or similar instruments, with recourse, or of repurchase agreements for purposes of relending or purchasing receivables and other similar obligations, provided, however, that commercial, industrial and other non-financial companies which borrow funds through any of these means for the limited purpose of financing their own needs or the needs of their agents or dealers shall not be considered as performing quasi-banking functions. Y. The term deposit substitutes shall mean an alternative from of obtaining funds from the public. The term public means borrowing from 20 or more individual or corporate lenders at any one time other than deposits, through the issuance, endorsement, or acceptance of debt instruments for the borrower's own account, for the purpose of relending or purchasing of receivables and other obligations, or financing their own needs or the needs of their agent or dealer. These instruments may include but need not be limited to bankers' acceptances, promissory notes, repurchase agreements, including reverse repurchase agreements entered into by and between the Banco Central ng Pilipinas (BSP) and any authorized agent bank, certificates of assignment or participation and similar instruments, with recourse provided, however, that debt instruments issued for interbank call loans with maturity of not more than 5 days to cover deficiency in reserves against deposit liabilities, including those between or among banks and quasi-banks, shall not be considered as deposit substitute debt instruments. Z. The term ordinary income includes any gain from the sale or exchange of property which is not a capital asset or property described in Section 39(a)(1). Any gain from the sale or exchange of property which is treated or considered under other provisions of this title as ordinary income shall be treated as gain from the sale or exchange of property which is not a capital asset as defined in Section 39(a)(1). The term ordinary loss includes any loss from the sale or exchange of property which is not a capital asset. Any loss from the sale or exchange of property which is treated or considered under other provisions of this title as ordinary loss shall be treated as loss from the sale or exchange of property which is not a capital asset. A. The term rank-and-file employees shall mean all employees who are holding neither managerial nor supervisory position as defined under existing provisions of the Labor Code of the Philippines, as amended. B. The term mutual fund company shall mean an open-end and close-end investment company as defined under the Investment Company Act. C. The term trade, business or profession shall not include performance of services by the taxpayer as an employee. D. The term regional or area headquarters shall mean a branch established in the Philippines by multinational companies and which headquarters do not earn or derive income from the Philippines, and which act as supervisory, communications and coordinating center for their affiliates, subsidiaries, or branches in the Asia-Pacific region and other foreign markets. E. The term regional operating headquarters shall mean a branch established in the Philippines by multinational companies which are engaged in any of the following services: general administration and planning, business planning and coordination, sourcing and procurement of raw materials and components, corporate finance advisory services, marketing control and sales promotion, training and personnel management, logistics services, research and development services and product development, technical support and maintenance, data processing and communications, and business development. FF. The term long-term deposit or investment certificate shall refer to certificate of time deposit or investment in the form of savings, common or individual trust funds, deposit substitutes, investment management accounts and other investments with a maturity period of no less than 5 years. The form of which shall be prescribed by the Banco Central NG Filipinas BSP and issued by banks only, not by non-bank financial intermediaries and finance companies, to individuals in denominations of 10,000 pesos P 10,000 and other denominations as may be prescribed by the BSP. GG. The term statutory minimum wage shall refer to the rate fixed by the Regional Tripartite Wage and Productivity Board, as defined by the Bureau of Labor and Employment Statistics, less of the Department of Labor and Employment, DOL. HH. The term minimum wage earner shall refer to a worker in the private sector paid a statutory minimum wage or to an employee in the public sector with compensation income of not more than their statutory minimum wage in the non-agricultural sector where he/she is assigned. Chapter 2. General Principles. SEC 23. General Principles of Income Taxation in the Philippines. Except when otherwise provided in this code. A citizen of the Philippines residing therein is taxable on all income derived from sources within and without the Philippines. B. A non-resident citizen is taxable only on income derived from sources within the Philippines. C. An individual citizen of the Philippines who is working and deriving income from abroad as an overseas contract worker is taxable only on income derived from sources within the Philippines, provided that a seaman who is a citizen of the Philippines and who receives compensation for services rendered abroad as a member of the complement of a vessel engaged exclusively in international trade shall be treated as an overseas contract worker. D. An alien individual, whether a resident or not of the Philippines, is taxable only on income derived from sources within the Philippines. E. A domestic corporation is taxable on all income derived from sources within and without the Philippines, and F. A foreign corporation, whether engaged or not in trade or business in the Philippines, is taxable only on income derived from sources within the Philippines. Chapter 3. Tax on individuals. SEC 24. Income tax rates. A. Rates of income tax on individual citizen and individual resident alien of the Philippines. 1. An income tax is hereby imposed A. On the taxable income defined in Section 31 of this Code, other than income subject to tax under subsections B, C, and D of this section, derived for each taxable year from all sources within and without the Philippines, be every individual citizen of the Philippines residing therein. B. On the taxable income defined in Section 31 of this Code, other than income subject to tax under subsections B, C, and D of this section, derived for each taxable year from all sources within the Philippines by an individual citizen of the Philippines who is residing outside of the Philippines, including overseas contract workers referred to in subsection C of Section 23 hereof, and C. On the taxable income defined in Section 31 of this Code, other than income subject to tax under subsections B, C, and D of this section, derived for each taxable year from all sources within the Philippines by an individual alien who is a resident of the Philippines. 2. The rates of tax on taxable income of individuals. The tax shall be computed in accordance with the net rates established in the following schedule. A. Tax schedule effective January 1, 2018 until December 31, 2022. Not over P 250,000, 0%. Over P 250,000 but not over P 400,000. 20% of the excess over P 250,000. Over P 400,000 but not over P 800,000. P 30,000 plus 25% of the excess over P 400,000. Over P 800,000 but not over P 2 million. P 130,000 plus 30% of the excess over P 800,000. Over P 2 million but not over P 8 million. P 490,000 plus 32% of the excess over P 2 million. Over P 8 million. P 2,410,000 plus 35% of the excess over P 8 million. Tax schedule effective January 1, 2023 and onwards. Not over P 250,000. 0%. Over P 250,000 but not over P 400,000. 15% of the excess over P 250,000. Over P 400,000 but not over P 800,000. P 22,500 plus 20% of the excess over P 400,000. Over P 800,000 but not over P 2 million. P 102,500 plus 25% of the excess over P 800,000. Over P 2 million but not over P 8 million. P 402,500 plus 30% of the excess over P 2 million. over P8 million, P2,202,500 plus 35% of the excess over P8 million. For married individuals, the husband and wife, subject to the provision of Section 51(d) hereof, shall compute separately their individual income tax based on their respective total taxable income, provided that if any income cannot be definitely attributed to or identified as income exclusively earned or realized by either of the spouses, the same shall be divided equally between the spouses for the purpose of determining their respective taxable income, provided that minimum wage earners as defined in Section 22(h) of this code shall be exempt from the payment of income tax on the taxable income, provided, further, that the holiday pay, overtime pay, night shift differential pay and hazard pay received by such minimum wage earners shall likewise be exempt from income tax. B. Rate of tax on income of purely self-employed individuals and/or professionals whose gross sales or gross receipts and other non-operating income does not exceed the value-added tax (VAT) threshold as provided in Section 109(b)(b). Self-employed individuals and/or professionals shall have the option to avail of an 8% tax on gross sales or gross receipts and other non-operating income in excess of 250,000 pesos (P 250,000) in lieu of the graduated income tax rates under subsection A2 of this section and the percentage tax under Section 116 of this code. C. Rate of tax for mixed income earners. Taxpayers earning both compensation income and income from business or practice of profession shall be subject to the following taxes. 1. All income from compensation, the rate prescribed under subsection A2 of this section. 2. All income from business or practice of profession. A. If total gross sales and/or gross receipts and other non-operating income do not exceed the VAT threshold as provided in Section 109(b)(b) of this code, the rates prescribed under subsection A2 of this section on taxable income, or 8% income tax based on gross sales or gross receipts and other non-operating income in lieu of the graduated income tax rates under subsection A2 of this section and the percentage tax under Section 116 of this code. B. If total gross sales and/or gross receipts and other non-operating income exceeds the VAT thresholds provided in Section 109(b)(b) of this code, the rates prescribed under subsection A2 of this section. B. Rate of tax on certain passive income. 1. Interest, royalties, prizes, and other winnings. A final tax at the rate of 20% is hereby imposed upon the amount of interest from any currency bank deposit and yield or any other monetary benefit from deposits, substitutes and from trust funds and similar arrangements, royalties, except on books, as well as other literary works and musical compositions, which shall be imposed a final tax of 10%. Prizes, except prizes amounting to 10,000 pesos (P 10,000) or less, which shall be subject to tax under subsection A of Section 24. And other winnings, except winning amounting to 10,000 pesos (P 10,000) or less from Philippine charity sweepstakes and lotto, which shall be exempt, derived from sources within the Philippines, provided, however, that interest income received by an individual taxpayer, except a non-resident individual, from a depository bank under the expanded foreign currency deposit system shall be subject to a final income tax at the rate of 15% of such interest income, provided, further, that interest income from long-term deposit or investment in the form of savings, common or individual trust funds, deposits, substitutes, investment management accounts and other investments evidenced by certificates in such form prescribed by the Banco Central ng Pilipinas BSP shall be exempt from the tax imposed under this subsection, provided, finally, that should the holder of the certificate pre-terminate the deposit or investment before the fifth year, a final tax shall be imposed on the entire income and shall be deducted and withheld by the depository bank from the proceeds of the long-term deposit or investment certificate based on the remaining maturity thereof. 4 years to less than 5 years 5%. 3 years to less than 4 years 12%, and less than 3 years 20%. 2. Cash and/or property dividends. A final tax at the rate of 10% shall be imposed upon the cash and/or property dividends actually or constructively received by an individual from a domestic corporation or from a joint stock company, insurance or mutual fund companies and regional operating headquarters of multinational companies, or on the share of an individual in the distributable net income after tax of a partnership, except a general professional partnership of which he is a partner, or on the share of an individual in the net income after tax of an association, a joint account, or a joint venture or consortium taxable as a corporation of which he is a member or co-venturer. C. Capital gains from sale of shares of stock not traded in the stock exchange. The provisions of Section 39(b), notwithstanding, a final tax at the rate of 15% is hereby imposed upon the net capital gains realized during the taxable year from the sale, barter, exchange or other disposition of shares of stock in a domestic corporation, except shares sold or disposed of through the stock exchange. D. Capital gains from sale of real property. 1. In general. The provisions of Section 39(b), notwithstanding a final tax of 6% based on the gross selling price or current fair market value as determined in accordance with Section 6(e) of this Code, whichever is higher, is hereby imposed upon capital gains presumed to have been realized from the sale, exchange, or other disposition of real property located in the Philippines classified as capital assets, including pacto de retro sales and other forms of conditional sales by individuals, including estates and trusts, provided that the tax liability, if any, on gains from sales or other dispositions of real property to the government or any of its political subdivisions or agencies or to government-owned or controlled corporations shall be determined either under Section 24 or under this subsection at the option of the taxpayer. 2. Exception. The provisions of paragraph 1 of this subsection to the contrary notwithstanding, capital gains presumed to have been realized from the sale or disposition of their principal residence by natural persons, the proceeds of which is fully utilized in acquiring or constructing a new principal residence within 18 calendar months from the date of sale or disposition, shall be exempt from the capital gains tax imposed under this subsection, provided that the historical cost or adjusted basis of the real property sold or disposed shall be carried over to the new principal residence built or acquired, provided, further, that the Commissioner shall have been duly notified by the taxpayer within 30 days from the date of sale or disposition through a prescribed return of his intention to avail of the tax exemption herein mentioned, provided, still further, that the said tax exemption can only be availed of once every 10 years, provided, finally, that if there is no full utilization of the proceeds of sale or disposition, the portion of the gain presumed to have been realized from the sale or disposition shall be subject to capital gains tax. For this purpose, the gross selling price or fair market value at the time of sale, whichever is higher, shall be multiplied by a fraction which the unutilized amount bears to the gross selling price in order to determine the taxable portion, and the tax prescribed under paragraph 1 of this subsection shall be imposed thereon. SEC 25. Tax on non-resident alien individual. A non-resident alien engaged in trade or business within the Philippines. 1. In general, a non-resident alien individual engaged in trade or business in the Philippines shall be subject to an income tax in the same manner as an individual citizen and a resident alien individual on taxable income received from all sources within the Philippines. A non-resident alien individual who shall come to the Philippines and stay therein for an aggregate period of more than 180 days during any calendar year shall be deemed a non-resident alien doing business in the Philippines. Section 22(g) of this Code notwithstanding. 2. Cash and or property dividends from a domestic corporation or joint stock company, or insurance or mutual fund company or regional operating headquarter or multinational company, or share in the distributable net income of a partnership except a general professional partnership joint account, joint venture taxable as a corporation or association, interests, royalties, prizes, and other winnings. Cash and or property dividends from a domestic corporation, or from a joint stock company, or from an insurance or mutual fund company, or from a regional operating headquarter of multinational company, or the share of a non-resident alien individual in the distributable net income after tax of a partnership except a general professional partnership of which he is a partner, or the share of a non-resident alien individual in the net income after tax of an association, a joint account, or a joint venture taxable as a corporation of which he is a member or a co-venturer. Interests, royalties, in any form, and prizes except prizes amounting to 10,000 pesos P10. 000.00 or less, which shall be subject to tax under subsection B1 of Section 24, and other winnings except winnings amounting to 10,000 pesos P10. 000.00 or less from Philippine Charity Sweepstakes Office PCSO games which shall be exempt shall be subject to an income tax of 20% on the total amount thereof, provided, however, that royalties on books as well as other literary works, and royalties on musical compositions shall be subject to a final tax of 10% on the total amount thereof, provided, further, that cinematographic films and similar works shall be subject to the tax provided under Section 28 of this Code, provided, furthermore, that interest income from long-term deposit or investment in the form of savings, common or individual trust funds, deposits, substitutes, investment management accounts and other investments evidenced by certificates in such form prescribed by the Banco Central ng Pilipinas BSP shall be exempt from the tax imposed under this subsection, provided, finally, that should the holder of the certificate pre-terminate the deposit or investment before the fifth year, a final tax shall be imposed on the entire income and shall be deducted and withheld by the depository bank from the proceeds of the long-term deposit or investment certificate based on the remaining maturity thereof. 4 years to less than 5 years 5%. 3 years to less than 4 years 12%, and less than 3 years 20%. 3. Capital gains Capital gains realized from sale, barter or exchange of shares of stock in domestic corporations not traded through the local stock exchange, and real property shall be subject to the tax prescribed under subsections C and D of Section 24. B. Non-resident alien individual not engaged in trade or business within the Philippines, there shall be levied, collected and paid for each taxable year upon the entire income received from all sources within the Philippines by every non-resident alien individual not engaged in trade or business within the Philippines as interest, cash and or property dividends, rents, salaries, wages, premiums, annuities, compensation, remuneration, emoluments, or other fixed or determinable annual or periodic or casual gains, profits, and income, and capital gains, a tax equal to 25% of such income. Capital gains realized by a non-resident alien individual not engaged in trade or business in the Philippines from the sale of shares of stock in any domestic corporation and real property shall be subject to the income tax prescribed under subsections C and D of Section 24. C. Alien individual employed by regional or area headquarters and regional operating headquarters of multinational companies. There shall be levied, collected and paid for each taxable year upon the gross income received by every alien individual employed by regional or area headquarters and regional operating headquarters established in the Philippines by multinational companies as salaries, wages, annuities, compensation, remuneration and other emoluments such as honoraria and allowances from such regional or area headquarters and regional operating headquarters, a tax equal to 15% of such gross income, provided, however, that the same tax treatment shall apply to Filipinos employed and occupying the same position as those of aliens employed by these multinational companies. For purposes of this chapter, the term multinational company means a foreign firm or entity engaged in international trade with affiliates or subsidiaries or branch offices in the Asia-Pacific region and other foreign markets. D. Alien individual employed by offshore banking units. There shall be levied, collected and paid for each taxable year upon the gross income received by every alien individual employed by offshore banking units established in the Philippines as salaries, wages, annuities, compensation, remuneration and other emoluments such as honoraria and allowances from such offshore banking units, a tax equal to 15% of such gross income, provided, however, that the same tax treatment shall apply to Filipinos employed and occupying the same positions as those of aliens employed by these offshore banking units. E. Alien individual employed by petroleum service contractor and subcontractor. An alien individual who is a permanent resident of a foreign country, but who is employed and assigned in the Philippines by a foreign service contractor or by a foreign service subcontractor, engaged in petroleum operations in the Philippines shall be liable to a tax of 15% of the salaries, wages, annuities, compensation, remuneration and other emoluments, such as honoraria and allowances, received from such contractor or subcontractor, provided, however, that the same tax treatment shall apply to a Filipino employed and occupying the same position as an alien employed by petroleum service contractor and subcontractor. Any income earned from all other sources within the Philippines by the alien employees referred to under subsections C, D, and E hereof shall be subject to the pertinent income tax, as the case may be imposed under this code. F. The preferential tax treatment provided in subsections C, D, and E of this section shall not be applicable to regional headquarters RHQs, regional operating headquarters ROHQs, offshore banking units OBUs, or petroleum service contractors and subcontractors registering with the Securities and Exchange Commission (SEC) after January 1, 2018, provided, however, that existing RHQs, ROHQs, OBUs or petroleum service contractors and subcontractors presently availing of preferential tax rates for qualified employees shall continue to be entitled to avail of the preferential tax rate for present and future qualified employees. Note: the amendments introduced by the Train Law on Section 6F was vetoed by the President. The veto message reads: I am constrained to veto the provision under Section 6F of the enrolled bill that effectively maintains the special tax rate of 15% of gross income for the aforementioned employees, to wit, provided, however, that existing RHQs, ROHQs, OBUs or petroleum service contractors and subcontractors presently availing of preferential tax rates for qualified employees shall continue to be entitled to avail of the preferential tax rate for present and future qualified employees. While I understand the laudable objective of the proposal, the provision is violative of the Equal Protection Clause under Section 1, Article 3 of the 1987 Constitution, as well as the rule of equity and uniformity in the application of the burden of taxation. Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. In line with this, the overriding consideration is the promotion of fairness of the tax system for individuals performing similar work. Given the significant reduction in the personal income tax, the employees of these firms should follow the regular tax rates applicable to other individual taxpayers. SEC 26. Tax liability of members of general professional partnerships. A general professional partnership as such shall not be subject to the income tax imposed under this chapter. Persons engaging in business as partners in a general professional partnership shall be liable for income tax only in their separate and individual capacities. For purposes of computing the distributive share of the partners, the net income of the partnership shall be computed in the same manner as a corporation. Each partner shall report as gross income his distributive share, actually or constructively received, in the net income of the partnership. Chapter IV. Tax on corporations. SEC 27. Rates of income tax on domestic corporations. A. In general. Except as otherwise provided in this code, an income tax rate of 25%, effective July 1, 2020, is hereby imposed upon the taxable income derived during each taxable year from all sources within and without the Philippines by every corporation, as defined in Section 22(b) of this code, and taxable under this title as a corporation, organized in or existing under the laws of the Philippines, provided that corporations with net taxable income not exceeding 5 million pesos (P 5 million.00) and with total assets not exceeding 100 million pesos (P 100 million.00), excluding land on which the particular business entity's office, plant, and equipment is situated during the taxable year for which the tax is imposed, shall be taxed at 20%. In the case of corporations adopting the fiscal year accounting period, the taxable income shall be computed without regard to the specific date when specific sales, purchases, and other transactions occur. Their income and expenses for the fiscal year shall be deemed to have been earned and spent equally for each month of the period. The corporate income tax rate shall be applied on the amount computed by multiplying the number of months covered by the new rate within the fiscal year by the taxable income of the corporation for the period, divided by 12. B. Proprietary educational institutions and hospitals. Proprietary educational institutions and hospitals which are non-profit shall pay a tax of 10% on the taxable income except those covered by subsection D hereof provided. That beginning July 1, 2020 until June 30, 2023, the tax rate herein imposed shall be 1%, provided, further, that if the gross income from unrelated trade, business or other activity exceeds 50% of the total gross income derived by such educational institutions or hospitals from all sources, the tax prescribed in subsection A hereof shall be imposed on the entire taxable income. For purposes of this subsection, the term unrelated trade, business or other activity means any trade, business or other activity, the conduct of which is not substantially related to the exercise or performance by such educational institution or hospital of its primary purpose or function. Proprietary means a private hospital, or any private school maintained and administered by private individuals or groups with an issued permit to operate from the Department of Education, DepEd, or the Commission on Higher Education, CHED, or the Technical Education and Skills Development Authority, TESDA, as the case may be, in accordance with existing laws and regulations. C. Government-owned or controlled corporations, agencies or instrumentalities. The provisions of existing special or general laws to the contrary notwithstanding, all corporations, agencies, or instrumentalities owned or controlled by the government, except the Government Service Insurance System (GSIS), the Social Security System (SS), the Home Development Mutual Fund (HDMF), the Philippine Health Insurance Corporation (PHIC), and the local water districts shall pay such rate of tax upon the taxable income as are imposed by this section upon corporations or associations engaged in a similar business, industry, or activity. D. Rates of tax on certain passive incomes. 1. Interest from deposits and yield or any other monetary benefit from deposit substitutes and from trust funds and similar arrangements, and royalties. A final tax at the rate of 20% is hereby imposed upon the amount of interest on currency bank deposit and yield or any other monetary benefit from deposit substitutes and from trust funds and similar arrangements received by domestic corporations, and royalties derived from sources within the Philippines, provided, however, that interest income derived by a domestic corporation from a depository bank under the expanded foreign currency deposit system shall be subject to a final income tax at the rate of 15% of such interest income. 2. Capital gains from the sale of shares of stock not traded in a stock exchange. A final tax at the rate of 15% shall be imposed on net capital gains realized during the taxable year from the sale, exchange or other disposition of shares of stock in a domestic corporation except shares sold or disposed of through the stock exchange. 3. Tax on income derived under the expanded foreign currency deposit system. Income derived by a depository bank under the expanded foreign currency deposit system from foreign currency transactions with non-residents offshore banking units in the Philippines. Local commercial banks including branches of foreign banks that may be authorized by the Bangko Sentral ng Pilipinas BSP to transact business with foreign currency deposit system shall be exempt. from all taxes, except net income from such transactions as may be specified by the Secretary of Finance upon recommendation by the Monetary Board to be subject to the regular income tax payable by banks, provided, however, that interest income from foreign currency loans granted by such depository banks under said expanded system to residents other than offshore banking units in the Philippines or other depository banks under the expanded system shall be subject to a final tax at the rate of 10%. Any income of non-residents, whether individuals or corporations, from transactions with depository banks under the expanded system shall be exempt from income tax. 4. Intercorporate dividends. Dividends received by a domestic corporation shall not be subject to tax under this title, provided that for foreign source dividends to be exempt, the funds from such dividends actually received or remitted into the Philippines are reinvested in the business operations of the domestic corporation in the Philippines within the next taxable year, from the time the foreign source dividends were received, and shall be limited to funding the working capital requirements, capital expenditures, dividend payments, investment in domestic subsidiaries, and infrastructure project, provided, further, that the domestic corporation holds directly at least 20% of the outstanding shares of the foreign corporation and has held the shareholdings for a minimum of 2 years at the time of the dividends distribution. 5. Capital gains realized from the sale, exchange or disposition of lands and/or buildings. A final tax of 6% is hereby imposed on the gain presumed to have been realized on the sale, exchange or disposition of lands and/or buildings which are not actually used in the business of a corporation and are treated as capital assets, based on the gross selling price of fair market value as determined in accordance with Section 6(e) of this code, whichever is higher of such lands and/or buildings. E. Minimum corporate income tax on domestic corporations. 1. Imposition of tax. A minimum corporate income tax of 2% of the gross income as of the end of the taxable year, as defined herein, is hereby imposed on a corporation taxable under this title, beginning on the 4th taxable year immediately following the year in which such corporation commenced its business operations, when the minimum income tax is greater than the tax computed under subsection A of this section for the taxable year, provided that effective July 1, 2020 until June 30, 2023, the rate shall be 1%. 2. Carry forward of excess minimum tax. Any excess of the minimum corporate income tax over the normal income tax as computed under subsection A of this section shall be carried forward and credited against the normal income tax for the 3 immediately succeeding taxable years. 3. Relief from the minimum corporate income tax under certain conditions. The Secretary of Finance is hereby authorized to suspend the imposition of the minimum corporate income tax on any corporation which suffers losses on account of prolonged labor dispute, or because of force majeure, or because of legitimate business reverses. The Secretary of Finance is hereby authorized to promulgate, upon recommendation of the Commissioner, the necessary rules and regulation that shall define the terms and conditions under which he may suspend the imposition of the minimum corporate income tax in a meritorious case. 4. Gross income defined. For purposes of applying the minimum corporate income tax provided under subsection E hereof, the term gross income shall mean gross sales less sales returns, discounts and allowances, and cost of goods sold. Cost of goods sold shall include all business expenses directly incurred to produce a merchandise to bring them to their present location and use. For a trading or merchandising concern, cost of goods sold shall include the invoice cost of the goods sold plus import duties, freight in transporting the goods to the place where the goods are actually sold, including insurance while the goods are in transit. For a manufacturing concern, cost of goods manufactured and sold shall include all costs of production of finished goods, such as raw materials used, direct labor and manufacturing overhead, freight cost, insurance premiums and other costs incurred to bring the raw materials to the factory or warehouse. In the case of taxpayers engaged in the sale of service, gross income means gross receipts less sales returns, allowances, discounts and cost of services. Cost of services shall mean all direct costs and expenses necessarily incurred to provide the services required by the customers and clients, including salaries and employee benefits of personnel, consultants and specialists directly rendering the service, and B. Cost of facilities directly utilized in providing the service, such as depreciation or rental of equipment used in cost of supplies. Provided, however, that in the case of banks, cost of services shall include interest expense. SEC 28. Rates of income tax on foreign corporations. A. Tax on resident foreign corporations. 1. In general. Except as otherwise provided in this code, a corporation organized, authorized, or existing under the laws of any foreign country, engaged in trade or business within the Philippines, shall be subject to an income tax equivalent to 25% of the taxable income derived in the preceding taxable year from all sources within the Philippines effective July 1, 2020. In the case of corporations adopting the fiscal year accounting period, the taxable income shall be computed without regard to the specific date when sales, purchases, and other transactions occur. Their income and expenses for the fiscal year shall be deemed to have been earned and spent equally for each month of the period. The corporate income tax rate shall be applied on the amount computed by multiplying the number of months covered by the new rate within a fiscal year by the taxable income of the corporation for the period, divided by 12. 2. Minimum corporate income tax on resident foreign corporations. A minimum corporate income tax of 2% of gross income, as prescribed under Section 27(e) of this Code, shall be imposed under the same conditions on a resident foreign corporation taxable under Paragraph 1 of this subsection, provided that effective July 1, 2020 until June 30, 2023, the rate shall be 1%. 3. International carrier. An international carrier doing business in the Philippines shall pay a tax of 2.5%, 21/2% on its gross Philippine billings as defined hereunder. An international air carrier. Gross Philippine billings refers to the amount of gross revenue derived from carriage of persons, excess baggage, cargo, and mail originating from the Philippines in a continuous and uninterrupted flight, irrespective of the place of sale or issue and the place of payment of a ticket or passage document, provided that tickets revalidated, exchanged and/or endorsed to another international airline form part of the gross Philippine billings if the passenger boards a plane in a port or point in the Philippines. Provided, further, that for a flight which originates from the Philippines, but transshipment of passenger takes place at any part outside the Philippines on another airline, only the aliquot portion of the cost of the ticket corresponding to the leg flown from the Philippines to the point of transshipment shall form part of gross Philippine billings. B. International shipping. Gross Philippine billings means gross revenue whether for passenger, cargo or mail originating from the Philippines up to final destination, regardless of the place of sale or payments of the passage or freight documents. Provided that international carriers doing business in the Philippines may avail of a preferential rate or exemption from the tax herein imposed on the gross revenue derived from the carriage of persons and their excess baggage on the basis of an applicable tax treaty or international agreement to which the Philippines is a signatory, or on the basis of reciprocity such that an international carrier whose home country grants income tax exemption to Philippine carriers shall likewise be exempt from the tax imposed under this provision. 4. Tax on branch profits remittances. Any profit remitted by a branch to its head office shall be subject to a tax of 15%, which shall be based on the total profits applied or earmarked for remittance without any deduction for the tax component thereof, except those activities which are registered with the Philippine Economic Zone Authority. The tax shall be collected and paid in the same manner as provided in Sections 57 and 58 of this Code, provided that interests, dividends, rents, royalties, including remuneration for technical services, salaries, wages, premiums, annuities, emoluments or other fixed or determinable annual, periodic or casual gains profits, income and capital gains received by a foreign corporation during each taxable year from all sources within the Philippines shall not be treated as branch profits unless the same are effectively connected with the conduct of its trade or business in the Philippines. 5. Regional or area headquarters and regional operating headquarters of multinational companies. A. Regional or area headquarters as defined in Section 22 DD shall not be subject to income tax. B. Regional operating headquarters as defined in Section 22 EE shall pay a tax of 10% of their taxable income, provided that effective January 1, 2022. Regional operating headquarters shall be subject to the regular corporate income tax. 6. Tax on certain incomes received by a resident foreign corporation. A. Interest from deposits and yield or any other monetary benefit from deposit substitutes, trust funds and similar arrangements and royalties. Interest from any currency bank deposit and yield or any other monetary benefit from deposit substitutes and from trust funds and similar arrangements and royalties derived from sources within the Philippines shall be subject to a final income tax at the rate of 20% of such interest, provided, however, that interest income derived by a resident foreign corporation from a depository bank under the expanded foreign currency deposit system shall be subject to a final income tax at the rate of 15% of such interest income. B. Income derived under the expanded foreign currency deposit system. Income derived by a depository bank under the expanded foreign currency deposit system from foreign currency transactions with non-residents offshore banking units in the Philippines. Local commercial banks including branches of foreign banks that may be authorized by the Bangko Sentral ng Pilipinas BSP to transact business with foreign currency deposit system units. And other depository banks under the expanded foreign currency deposit system shall be exempt from all taxes, except net income from such transactions as may be specified by the Secretary of Finance, upon recommendation by the Monetary Board, to be subject to the regular income tax payable by banks, provided, however, that interest income from foreign currency loans granted by such depository banks under said expanded system to residents other than offshore banking units in the Philippines or other depository banks under the expanded system shall be subject to a final tax at the rate of 10%. Any income of non-residents, whether individuals or corporations, from transactions with depository banks under the expanded system shall be exempt from income tax. C. Capital gains from sale of shares of stock not traded in the stock exchange. A final tax at the rate of 15%. 15% is hereby imposed upon the net capital gains realized during the taxable year from the sale, barter, exchange or other disposition of shares of stock in a domestic corporation except shares sold or disposed of through the stock exchange. D. Intercorporate dividends. Dividends received by a resident foreign corporation from a domestic corporation liable to tax under this code shall not be subject to tax under this title. B. Tax on non-resident foreign corporation. 1. In general, except as otherwise provided in this code, a foreign corporation not engaged in trade or business in the Philippines, effective January 1, 2021, shall pay a tax equal to 25% of the gross income received during each taxable year from all sources within the Philippines, such as interest, dividends, rents, royalties, salaries, premiums, except reinsurance premiums, annuities, emoluments or other fixed or determinable annual, periodic or casual gains, profits and income, and capital gains, except capital gains subject to tax under subparagraph 5c. 2. Non-resident cinematographic film owner, lessor or distributor. A cinematographic film owner, lessor or distributor shall pay a tax of 25% of its gross income from all sources within the Philippines. 3. Non-resident owner or lessor of vessels chartered by Philippine nationals. A non-resident owner or lessor of vessels shall be subject to a tax of 4.5% to gross rentals. Lease or charter fees from leases or charters to Filipino citizens or corporations, as approved by the Maritime Industry Authority. 4. Non-resident owner or lessor of aircraft, machineries and other equipment. Rentals, charters and other fees derived by a non-resident lessor of aircraft, machineries and other equipment shall be subject to a tax of 7.5% of gross rentals or fees. 5. Tax on certain incomes received by a non-resident foreign corporation. A. Interest on foreign loans. A final withholding tax at the rate of 20% is hereby imposed on the amount of interest on foreign loans contracted on or after August 1, 1986. B. Intercorporate dividends. A final withholding tax at the rate of 15% is hereby imposed on the amount of cash and/or property dividends received from a domestic corporation, which shall be collected and paid as provided in Section 57A of this code, subject to the condition that the country in which the non-resident foreign corporation is domiciled shall allow the credit against the tax due from the non-resident foreign corporation taxes deemed to have been paid in the Philippines equivalent to 15%, which represents the difference between the regular income tax and the 15% tax on dividends as provided in this subparagraph, provided that effective July 1, 2020. The credit against the tax due shall be equivalent to the difference between the regular income tax rate provided in Section 28B(1) of this code and the 15% tax on dividends. C. Capital gains from sale of shares of stock not traded in the stock exchange. A final tax at the rate of 15% is hereby imposed upon the net capital gains realized during the taxable year from the sale, barter, exchange or other disposition of shares of stock in a domestic corporation, except shares sold or disposed of through the stock exchange. SEC 29. Repealed. SEC 30. Exemptions from tax on corporations. The following organizations shall not be taxed under this title in respect to income received by them as such. A. Labor, agricultural or horticultural organization not organized principally for profit. B. Mutual savings bank not having a capital stock represented by shares, and cooperative bank without capital stock organized and operated for mutual purposes and without profit. C. A beneficiary society, order or association, operating for the exclusive benefit of the members such as a fraternal organization operating under the lodge system, or mutual aid association or a non-stock corporation organized by employees providing for the payment of life, sickness, accident, or other benefits exclusively to the members of such society, order, or association, or non-stock corporation or their dependents. D. Cemetery company owned and operated exclusively for the benefit of its members. E. Non-stock corporation or association organized and operated exclusively for religious, charitable, scientific, athletic, or cultural purposes, or for the rehabilitation of veterans. No part of its net income or asset shall belong to or inure to the benefit of any member, organizer, officer or any specific person. F. Business League Chamber of Commerce, or Board of Trade, not organized for profit and no part of the net income of which inures to the benefit of any private stockholder, or individual. G. Civic league or organization not organized for profit but operated exclusively for the promotion of social welfare. H. A non-stock and non-profit educational institution. I. Government educational institution. J. Farmers or other mutual typhoon or fire insurance company, mutual ditch or irrigation company, mutual or cooperative telephone company, or like organization of a purely local character, the income of which consists solely of assessments, dues, and fees collected from members for the sole purpose of meeting its expenses, and K. Farmers, fruit growers, store-like association organized and operated as a sales agent for the purpose of marketing the products of its members and turning back to them the proceeds of sales, less the necessary selling expenses on the basis of the quantity of produce finished by them. Notwithstanding the provisions in the preceding paragraphs, the income of whatever kind and character of the foregoing organizations from any of their properties, real or personal, or from any of their activities conducted for profit regardless of the disposition made of such income, shall be subject to tax imposed under this code. Chapter V. Computation of taxable income. SEC 31. Taxable income defined. The term taxable income means the pertinent items of gross income specified in this code, less the deductions, if any, authorized for such types of income by this code or other special laws. Chapter V. Computation of gross income. SEC 32. Gross income. A. General definition. Except when otherwise provided in this title, gross income means all income derived from whatever source, including, but not limited to, the following items. 1. Compensation for services in whatever form paid, including, but not limited to, fees, salaries, wages, commissions, and similar items. 2. Gross income derived from the conduct of trade or business or the exercise of a profession. 3. Gains derived from dealings in property. 4. Interests. 5. Rents. 6. Royalties. 7. Dividends. 8. Annuities. 9. Prizes and winnings. 10. Pensions, and 11. Partners' distributive share from the net income of the general professional partnership. B. Exclusions from gross income. The following items shall not be included in gross income and shall be exempt from taxation under this title. 1. Life insurance. The proceeds of life insurance policies paid to the heirs or beneficiaries upon the death of the insured, whether in a single sum or otherwise. But if such amounts are held by the insurer under an agreement to pay interest thereon, the interest payments shall be included in gross income. 2. Amount received by insured as return of premium. The amount received by the insured as a return of premiums paid by him under life insurance, endowment, or annuity contract, either during the term or at the maturity of the term mentioned in the contract or upon surrender of the contract. 3. Gifts, bequests, and devises. The value of property acquired by gift, bequest, devise, or descent, provided, however, that income from such property, as well as gift, bequest, devise, or descent of income from any property, in cases of transfers of divided interest, shall be included in gross income. 4. Compensation for injuries or sickness. Amounts received through accident or health insurance or under Workmen's Compensation Acts, as compensation for personal injuries or sickness, plus the amounts of any damages received, whether by suit or agreement, on account of such injuries or sickness. 5. Income exempt under treaty. Income of any kind, to the extent required by any treaty obligation binding upon the government of the Philippines. 6. Retirement benefits, pensions, gratuities, etc. A. Retirement benefits received under Republic Act No. 7641 and those received by officials and employees of private firms, whether individual or corporate, in accordance with a reasonable private benefit plan maintained by the employer, provided that the retiring official or employee has been in the service of the same employer for at least 10 years and is not less than 50 years of age at the time of his retirement, provided further, that the benefits granted under this subparagraph shall be availed of by an official or employee only once. For purposes of this subsection, the term reasonable private benefit plan means a pension, gratuity, stock bonus or profit-sharing plan maintained by an employer for the benefit of some or all of his officials or employees, wherein contributions are made by such employer for the officials or employees, or both, for the purpose of distributing to such officials and employees the earnings and principal of the fund thus accumulated, and wherein it is provided in said plan that at no time shall any part of the corpus or income of the fund be used for, or be diverted to, any purpose other than for the exclusive benefit of the said officials and employees. B. Any amount received by an official or employee or by his heirs from the employer as a consequence of separation of such official or employee from the service of the employer because of death, sickness or other physical disability or for any cause beyond the control of the said official or employee. C. The provisions of any existing law to the contrary notwithstanding, Social Security benefits, retirement gratuities, pensions and other similar benefits received by resident or non-resident citizens of the Philippines or aliens who come to reside permanently in the Philippines from foreign government agencies and other institutions, private or public. D. Payments of benefits due or to become due to any person residing in the Philippines under the laws of the United States administered by the United States Veterans Administration. E. Benefits received from or enjoyed under the Social Security system in accordance with the provisions of Republic Act No. 8,282. F. Benefits received from the GSIS under Republic Act No. 8,291, including retirement gratuity received by government officials and employees. 7. Miscellaneous items. A. Income derived by foreign government. Income derived from investments in the Philippines in loans, stocks, bonds or other domestic securities, or from interest on deposits in banks in the Philippines by foreign governments. E. Financing institutions owned, controlled, or enjoying refinancing from foreign governments and international or regional financial institutions established by foreign governments. B. Income derived by the government or its political subdivisions. Income derived from any public utility or from the exercise of any essential governmental function accruing to the government of the Philippines or to any political subdivision thereof. C. Prizes and awards. Prizes and awards made primarily in recognition of religious, charitable, scientific, educational, artistic, literary, or civic achievement, but only if I. The recipient was selected without any action on his part to enter the contest or proceeding, and E. The recipient is not required to render substantial future services as a condition to receiving the prize or award. D. Prizes and awards in sports competition. All prizes and awards granted to athletes in local and international sports competitions and tournaments, whether held in the Philippines or abroad and sanctioned by their national sports associations. E. 13th month pay and other benefits. Gross benefits received by officials and employees of public and private entities, provided, however, that the total exclusion under this subparagraph shall not exceed 90,000 pesos, P. 90,000, which shall cover I. Benefits received by officials and employees of the national and local government pursuant to Republic Act No. 6,686. E. Benefits received by employees pursuant to Presidential Decree No. 851, as amended by Memorandum Order No. 28, dated August 13, 1986. E. Benefits received by officials and employees not covered by Presidential Decree No. 851, as amended by Memorandum Order No. 28, dated August 13, 1986, and IV. Other benefits such as productivity incentives and Christmas bonus. FGSIS, assessed Medicare and other contributions. GSIS, assessed Medicare and par-guided contributions, and union dues of individuals. G. Gains from the sale of bonds, debentures or other certificate of indebtedness. Gains realized from the same or exchange or retirement of bonds, debentures or other certificate of indebtedness with a maturity of more than 5 years. H. Gains from redemption of shares in mutual fund. Gains realized by the investor upon redemption of shares of stock in a mutual fund company as defined in Section 22 BB of this Code. SEC 33. Special treatment of fringe benefit. A. Imposition of tax. Effective January 1, 2018 and onwards, a final tax of 35%, 35% is hereby imposed on the grossed-up monetary value of fringe benefit furnished or granted to the employee, except rank-and-file employees defined herein by the employer, whether an individual or a corporation, unless the fringe benefit is required by the nature of or necessary to the trade, business or profession of the employer, or when the fringe benefit is for the convenience or advantage of the employer. The tax herein imposed is payable by the employer, which tax shall be paid in the same manner as provided for under Section 57A of this Code. The grossed-up monetary value of the fringe benefit shall be determined by dividing the actual monetary value of the fringe benefit by 65%, 65%, effective January 1, 1998. 67%, 67%, effective January 1, 1999, and 68%, 68%, effective January 1, 2000 and thereafter, provided, however, that fringe benefit furnished to employees and taxable under subsections B, C, D, and E of Section 25 shall be taxed at the applicable rates imposed thereat, provided, further, that the grossed-up monetary value of the fringe benefit shall be determined by dividing the actual monetary value of the fringe benefit by the difference between 100%, 100%, and the applicable rates of income tax under subsections B, C, D, and E of Section 25. B. Fringe benefit defined. For purposes of this section, the term fringe benefit means any good, service or other benefit furnished or granted in cash or in kind by an employer to an individual employee, except rank-and-file employees as defined herein, such as but not limited to the following. 1. Housing. 2. Expense account. 3. Vehicle of any kind. 4. Household personnel, such as maid, driver, and others. 5. Interest on loan at less than market rate to the extent of the difference between the market rate and actual rate granted. 6. Membership fees, dues and other expenses borne by the employer for the employee in social and athletic clubs or other similar organizations. 7. Expenses for foreign travel. 8. Holiday and vacation expenses. 9. Educational assistance to the employee or his dependents, and 10. Life or health insurance and other non-life insurance premiums or similar amounts in excess of what the law allows. C. Fringe benefits not taxable. The following fringe benefits are not taxable under this section. 1. Fringe benefits which are authorized and exempted from tax under special laws. 2. Contributions of the employer for the benefit of the employee to retirement, insurance and hospitalization benefit plans. 3. Benefits given to the rank-and-file employees, whether granted under a collective bargaining agreement or not, and 4. De minimis benefits as defined in the rules and regulations to be promulgated by the Secretary of Finance, upon recommendation of the Commissioner. The Secretary of Finance is hereby authorized to promulgate, upon recommendation of the Commissioner, such rules and regulations as are necessary to carry out efficiently and fairly the provisions of this section, taking into account the peculiar nature and special need of the trade, business or profession of the employer. Chapter 7. Allowable deductions. SEC 34. Deductions from gross income. Except for taxpayers earning compensation income arising from personal services rendered under an employer-employee relationship, when no deduction shall be allowed under this section. In computing taxable income subject to income tax under sections 24A, 25A, 26, 27A, B, and C, and 28(1), there shall be allowed the following deductions from gross income. A. Expenses. 1. Ordinary and necessary trade, business or professional expenses. A. In general. There shall be allowed as deduction from gross income all the ordinary and necessary expenses paid or incurred during the taxable year in carrying on or which are directly attributable to the development, management, operation and or conduct of the trade, business or exercise of a profession, including I. A reasonable allowance for salaries, wages, and other forms of compensation for personal services actually rendered, including the grossed-up monetary value of fringe benefit furnished or granted by the employer to the employee, provided that the final tax imposed under Section 33 hereof has been paid. E. A reasonable allowance for travel expenses, here and abroad, while away from home in the pursuit of trade, business or profession. E. A reasonable allowance for rentals and or other payments which are required as a condition for the continued use or possession, for purposes of the trade, business or profession, of property to which the taxpayer has not taken or is not taking title or in which he has no equity other than that of a lessee, user or possessor. IV. A reasonable allowance for entertainment, amusement and recreation expenses during the taxable year, that are directly connected to the development, management and operation of the trade, business or profession of the taxpayer, or that are directly related to or in furtherance of the conduct of his or its trade, business or exercise of a profession, not to exceed such ceilings as the Secretary of Finance may, by rules and regulations, prescribe, upon recommendation of the Commissioner, taking into account the needs as well as the special circumstances, nature and character of the industry, trade, business, or profession of the taxpayer, provided that any expense incurred for entertainment, amusement or recreation that is contrary to law, morals, public policy or public order shall in no case be allowed as a deduction. V. An additional deduction from taxable income of one half of the value of labor training expenses incurred for skills development of enterprise-based trainees enrolled in public senior high schools, public higher education institutions, or public technical and vocational institutions and duly covered by an apprenticeship agreement under Presidential Decree No. 442, Series of 1974, or the Labor Code of the Philippines, as amended, shall be granted to enterprises, provided, further, that for the additional deduction for enterprise-based training of students from public educational institutions, the enterprise shall secure proper certification from the DepEd, TESDA, or CHED. Provided, finally, that such deduction shall not exceed 10% to direct labor wage. B. Substantiation requirements. No deduction from gross income shall be allowed under subsection hereof unless the taxpayer shall substantiate with sufficient evidence, such as official receipts or other adequate records, I. The amount of the expense being deducted, and E. The direct connection or relation of the expense being deducted to the development, management, operation and or conduct of the trade, business or profession of the taxpayer. C. Bribes, kickbacks and other similar payments. No deduction from gross income shall be allowed under subsection hereof for any payment made, directly or indirectly, to an official or employee of the national government, or to an official or employee of any local government unit, or to an official or employee of a government-owned or controlled corporation, or to an official or employee or representative of a foreign government, or to a private corporation, general professional partnership, or a similar entity, if the payment constitutes a bribe or kickback. 2. Expenses allowable to private educational institutions. In addition to the expenses allowable as deductions under this chapter, a private educational institution, referred to under Section 27(b) of this Code, may at its option elect either A. To deduct expenditures otherwise considered as capital outlays of depreciable assets incurred during the taxable year for the expansion of school facilities, or B. To deduct allowance for depreciation thereof under subsection F hereof. B. Interest. 1. In general. The amount of interest paid or incurred within a taxable year on indebtedness in connection with the taxpayer's profession, trade or business shall be allowed as deduction from gross income. Provided, however, that the taxpayer's otherwise allowable deduction for interest expense shall be reduced by 20% of the interest income subjected to final tax, provided, finally, that if the interest income tax is adjusted in the future, the interest expense reduction rate shall be adjusted accordingly based on the prescribed standard formula as defined in the rules and regulations to be promulgated by the Secretary of Finance, upon the recommendation of the Commissioner of Internal Revenue. 2. Exceptions. No deduction shall be allowed in respect of interest under the succeeding subparagraphs. A. If within the taxable year an individual taxpayer reporting income on a cash basis incurs an indebtedness on which an interest is paid in advance through discount or otherwise, provided that such interest shall be allowed as a deduction in the year the indebtedness is paid, provided, further, that if the indebtedness is payable in periodic amortizations, the amount of interest which corresponds to the amount of the principal amortized or paid during the year shall be allowed as deduction in such taxable year. B. If both the taxpayer and the person to whom the payment has been made or is to be made are persons specified under Section 36B, or C. If the indebtedness is incurred to finance petroleum exploration. 3. Optional treatment of interest expense. After option of the taxpayer, interest incurred to acquire property used in trade, business or exercise of a profession may be allowed as a deduction or treated as a capital expenditure. C. Taxes. 1. In general, tax paid or incurred within the taxable year in connection with the taxpayer's profession, trade or business shall be allowed as deduction, except A. The income tax provided for under this title. B. Income taxes imposed by authority of any foreign country. But this deduction shall be allowed in the case of a taxpayer who does not signify in his return his desire to have to any extent the benefits of paragraph 3 of this subsection relating to credits for taxes of foreign countries. C. Estate and donors taxes, and D. Taxes assessed against local benefits of a kind tending to increase the value of the property assessed. Provided that taxes allowed under this subsection, when refunded or credited, shall be included as part of gross income in the year of receipt to the extent of the income tax benefit of said deduction. 2. Limitations on deductions. In the case of a non-resident alien individual engaged in trade or business in the Philippines and a resident foreign corporation, the deductions for taxes provided in paragraph 1 of this subsection C shall be allowed only if and to the extent that they are connected with income from sources within the Philippines. 3. Credit against tax for taxes of foreign countries. If the taxpayer signifies in his return his desire to have the benefits of this paragraph, the tax imposed by this title shall be credited with A. Citizen and domestic corporation. In the case of a citizen of the Philippines and of a domestic corporation, the amount of income taxes paid or incurred during the taxable year to any foreign country, and B. Partnerships and estates. In the case of any such individual who is a member of a general professional partnership or a beneficiary of an estate or trust, his proportionate share of such taxes of the general professional partnership or the estate or trust paid or incurred during the taxable year to a foreign country. If his distributive share of the income of such partnership or trust is reported for taxation under this title, an alien individual in a foreign corporation shall not be allowed the credits against the tax for the taxes of foreign countries allowed under this paragraph. 4. Limitations on credit. The amount of the credit taken under this section shall be subject to each of the following limitations. A. The amount of the credit in respect to the tax paid or incurred to any country shall not exceed the same proportion of the tax against which such credit is taken, which the taxpayer's taxable income from sources within such country under this title bears to his entire taxable income for the same taxable year, and B. The total amount of the credit shall not exceed the same proportion of the tax against which such credit is taken, which the taxpayer's taxable income from sources without the Philippines taxable under this title bears to his entire taxable income for the same taxable year. 5. Adjustments on payment of incurred taxes. If accrued taxes when paid differ from the amounts claimed as credits by the taxpayer, or if any tax paid is refunded in whole or in part, the taxpayer shall notify the Commissioner, who shall redetermine the amount of the tax for the year or years affected, and the amount of tax due upon such redetermination, if any, shall be paid by the taxpayer upon notice and demand by the Commissioner, or the amount of tax overpaid, if any, shall be credited or refunded to the taxpayer. In the case of such a tax incurred but not paid, the Commissioner, as a condition precedent to the allowance of this credit, may require the taxpayer to give a bond with sureties satisfactory to and to be approved by the Commissioner in such sum as he may require, conditioned upon the payment by the taxpayer of any amount of tax found due upon any such redetermination. The bond herein prescribed shall contain such further conditions as the Commissioner may require. 6. Year in which credit taken. The credits provided for in subsection C3 of this section may, at the option of the taxpayer and irrespective of the method of accounting employed in keeping his books, be taken in the year which the taxes of the foreign country were incurred, subject, however, to the conditions prescribed in subsection C5 of this section. If the taxpayer elects to take such credits in the year in which the taxes of the foreign country accrued, the credits for all subsequent years shall be taken upon the same basis, and no portion of any such taxes shall be allowed as a deduction in the same or any succeeding year. 7. Proof of credits. The credits provided in subsection C3 hereof shall be allowed only if the taxpayer establishes to the satisfaction of the Commissioner the following: A. The total amount of income derived from sources without the Philippines. B. The amount of income derived from each country, the tax paid or incurred to which is claimed as a credit under said paragraph, such amount to be determined under rules and regulations prescribed by the Secretary of Finance, and C. All other information necessary for the verification and computation of such credits. D. Losses. 1. In general, losses actually sustained during the taxable year and not compensated for by insurance or other forms of indemnity shall be allowed as deductions. A. If incurred in trade, profession or business. B. Of property connected with the trade, business or profession, if the loss arises from fires, storms, shipwreck, or other casualties, or from robbery, theft or embezzlement. The Secretary of Finance, upon recommendation of the Commissioner, is hereby authorized to promulgate rules and regulations prescribing, among other things, the time and manner by which the taxpayer shall submit a declaration of loss sustained from casualty or from robbery, theft or embezzlement during the taxable year, provided, however, that the time limit to be so prescribed in the rules and regulations shall not be less than 30 days nor more than 90 days from the date of discovery of the casualty or robbery, theft or embezzlement giving rise to the loss. C. No loss shall be allowed as a deduction under this subsection if at the time of the filing of the return, such loss has been claimed as a deduction for estate tax purposes in the estate tax return. 2. Proof of loss. In the case of a non-resident alien individual or foreign corporation, the losses deductible shall be those actually sustained during the year incurred in business, trade or exercise of a profession conducted within the Philippines, when such losses are not compensated for by insurance or other forms of indemnity. The Secretary of Finance, upon recommendation of the Commissioner, is hereby authorized to promulgate rules and regulations prescribing, among other things, the time and manner by which the taxpayer shall submit a declaration of loss sustained from casualty or from robbery, theft or embezzlement during the taxable year, provided that the time to be so prescribed in the rules and regulations shall not be less than 30 days nor more than 90 days from the date of discovery of the casualty or robbery, theft or embezzlement giving rise to the loss, and 3. Net operating loss carryover. The net operating loss of the business or enterprise for any taxable year immediately preceding the current taxable year, which had not been previously offset as deduction from gross income, shall be carried over as a deduction from gross income for the next three consecutive taxable years immediately following the year of such loss, provided, however, that any net loss incurred in a taxable year during which the taxpayer was exempt from income tax shall not be allowed as a deduction under this subsection. Provided, further, that a net operating loss carryover shall be allowed only if there has been no substantial change in the ownership of the business or enterprise in that, i.e. not less than 75% in nominal value of outstanding issued shares, if the business is in the name of a corporation, is held by or on behalf of the same persons, or not less than 75% of the paid-up capital of the corporation, if the business is in the name of a corporation, is held by or on behalf of the same persons. For purposes of this subsection, the term net operating loss shall mean the excessive allowable deduction over gross income of the business in a taxable year, provided that for mines other than oil and gas wells, a net operating loss without the benefit of incentives provided for under Executive Order No. 226, as amended, otherwise known as the Omnibus Investments Code of 1987. Incurred in any of the first 10 years of operation may be carried over as a deduction from taxable income for the next 5 years immediately following the year of such loss. The entire amount of the loss shall be carried over to the first of the 5 taxable years following the loss, and any portion of such loss which exceeds the taxable income of such first year shall be deducted in like manner from the taxable income of the next remaining 4 years. 4. Capital losses. A. Limitations. Loss from sales or exchanges of capital assets shall be allowed only to the extent provided in Section 39. B. Securities becoming worthless. If securities as defined in Section 22(t) become worthless during the taxable year and are capital assets, the loss resulting therefrom shall, for purposes of this title, be considered as a loss from the sale or exchange, on the last day of such taxable year, of capital assets. 5. Losses from wash sales of stock or securities. Losses from wash sales of stock or securities as provided in Section 38. 6. Wagering losses. Losses from wagering transactions shall be allowed only to the extent of the gains from such transactions. 7. Abandonment losses. A. In the event a contract area where petroleum operations are undertaken is partially or wholly abandoned, all accumulated exploration and development expenditures pertaining thereto shall be allowed as a deduction, provided that accumulated expenditures incurred in that area prior to January 1, 1979 shall be allowed as a deduction only from any income derived from the same contract area. In all cases, notices of abandonment shall be filed with the Commissioner. B. In case a producing well is subsequently abandoned, the unamortized costs thereof, as well as the undepreciated costs of equipment directly used therein, shall be allowed as a deduction in the year such well, equipment or facility is abandoned by the contractor, provided that if such abandoned well is re-entered and production is resumed, or if such equipment or facility is restored into service, the said costs shall be included as part of gross income in the year of resumption or restoration and shall be amortized or depreciated, as the case may be. E. Bad debts. 1. In general, debts due to the taxpayer actually ascertained to be worthless and charged off within the taxable year except those not connected with profession, trade or business and those sustained in a transaction entered into between parties mentioned under Section 36B of this Code, provided that recovery of bad debts previously allowed as deduction in the preceding years shall be included as part of the gross income in the year of recovery to the extent of the income tax benefit of said deduction. 2. Securities becoming worthless. If securities, as defined in Section 22(t), are ascertained to be worthless and charged off within the taxable year and are capital assets, the loss resulting therefrom shall, in the case of a taxpayer other than a bank or trust company incorporated under the laws of the Philippines, a substantial part of whose business is the receipt of deposits, for the purpose of this title, be considered as a loss from the sale or exchange, on the last day of such taxable year, of capital assets. F. Depreciation. 1. General rule. There shall be allowed as a depreciation deduction a reasonable allowance for the exhaustion, wear and tear, including reasonable allowance for obsolescence to property used in the trade or business. In the case of property held by one person for life with remainder to another person, the deduction shall be computed as if the life tenant were the absolute owner of the property and shall be allowed to the life tenant. In the case of property held in trust, the allowable deduction shall be apportioned between the income beneficiaries and the trustees in accordance with the pertinent provisions of the instrument creating the trust, or in the absence of such provisions, on the basis of the trust income allowable to each. 2. Use of certain methods and rates. The term reasonable allowance, as used in the preceding paragraph, shall include, but not limited to, an allowance computed in accordance with rules and regulations prescribed by the Secretary of Finance upon recommendation of a Commissioner, under any of the following methods. A. The straight line method. B. Declining balance method, using a rate not exceeding twice the rate which would have been used had the annual allowance been computed under the method described in subsection F1. C. The sum of the years did it method, and D. Any other method which may be prescribed by the Secretary of Finance upon recommendation of the Commissioner. 3. Agreement as to useful life on which depreciation rate is based, where under rules and regulations prescribed by the Secretary of Finance upon recommendation of the Commissioner, the taxpayer and the Commissioner have entered into an agreement in writing specifically dealing with the useful life and rate of depreciation of any property. The rate so agreed upon shall be binding on both the taxpayer and the national government in the absence of facts and circumstances not taken into consideration during the adoption of such agreement. The responsibility of establishing the existence of such facts and circumstances shall rest with the party initiating the modification. Any change in the agreed rate and useful life of the depreciable property as specified in the agreement shall not be effective for taxable years prior to the taxable year in which notice in writing by certified mail or registered mail is served by the party initiating such change to the other party to the agreement. Provided, however, that where the taxpayer has adopted such useful life and depreciation rate for any depreciable and claimed the depreciation expenses as deduction from his gross income, without any written objection on the part of the Commissioner or his duly authorized representatives, the aforesaid useful life and depreciation rate so adopted by the taxpayer for the aforesaid depreciable asset shall be considered binding for purposes of this subsection. 4. Depreciation of properties used in petroleum operations. An allowance for depreciation in respect of all properties directly related to production of petroleum initially placed in service in a taxable year shall be allowed under the straight line or declining balance method of depreciation at the option of the service contractor. However, if the service contractor initially elects the declining balance method, it may at any subsequent date shift to the straight line method. The useful life of properties used in or related to production of petroleum shall be 10 years of such shorter life as may be permitted by the Commissioner. Properties not used directly in the production of petroleum shall be depreciated under the straight line method on the basis of an estimated useful life of 5 years. 5. Depreciation of properties used in mining operations. An allowance for depreciation in respect of all properties used in mining operations other than petroleum operations shall be computed as follows. A. At the normal rate of depreciation if the expected life is 10 years or less, or B. Depreciated over any number of years between 5 years and the expected life if the latter is more than 10 years, and the depreciation thereon allowed as deduction from taxable income. Provided that the contractor notifies the Commissioner at the beginning of the depreciation period which depreciation rate allowed by this section will be used. 6. Depreciation deductible by non-resident aliens engaged in trade or business or resident foreign corporations. In the case of a non-resident alien individual engaged in trade or business or resident foreign corporation, a reasonable allowance for the deterioration of property arising out of its use or employment or its non-use in the business, trade or profession shall be permitted only when such property is located in the Philippines. G. Depletion of oil and gas wells and mines. 1. In general. In the case of oil and gas wells or mines, a reasonable allowance for depletion or amortization computed in accordance with the cost depletion method shall be granted under rules and regulations to be prescribed by the Secretary of Finance, upon recommendation of the Commissioner. Provided that when the allowance for depletion shall equal the capital invested, no further allowance shall be granted, provided, further, that after production in commercial quantities has commenced, certain intangible exploration and development drilling costs shall be deductible in the year incurred if such expenditures are incurred for non-producing wells and or mines. Or B. Shall be deductible in full in the year paid or incurred, or at the election of the taxpayer. They may be capitalized and amortized if such expenditures incurred for producing wells and or mines in the same contract area. Intangible costs in petroleum operations refers to any cost incurred in petroleum operations which in itself has no salvage value and which is incidental to and necessary for the drilling of wells and preparation of wells for the production of petroleum, provided that said costs shall not pertain to the acquisition or improvement of property of a character subject to the allowance for depreciation, except that the allowances for depreciation on such property shall be deductible under this subsection. Any intangible exploration, drilling and development expenses allowed as a deduction in computing taxable income during the year shall not be taken into consideration in computing the adjusted cost basis for the purpose of computing allowable cost depletion. 2. Election to deduct exploration and development expenditures. In computing taxable income from mining operations, the taxpayer may at his option deduct exploration and development expenditures accumulated as cost or adjusted basis for cost depletion as of date of prospecting, as well as exploration and development expenditures paid or incurred during the taxable year, provided that the amount deductible for exploration and development expenditures shall not exceed 25% of the net income from mining operations computed without the benefit of any tax incentives under existing laws. The actual exploration and development expenditures minus 25% of the net income from mining shall be carried forward to the succeeding years until fully deducted. The election by the taxpayer to deduct the exploration and development expenditures is irrevocable and shall be binding in succeeding taxable years. Net income from mining operations, as used in this subsection, shall mean gross income from operations less allowable deductions which are necessary or related to mining operations. Allowable deductions shall include mining, milling and marketing expenses, and depreciation of properties directly used in the mining operations. This paragraph shall not apply to expenditures for the acquisition or improvement of property of a character which is subject to the allowance for depreciation. In no case shall this paragraph apply with respect to amounts paid or incurred for the exploration and development of oil and gas. The term exploration expenditures means expenditures paid or incurred for the purpose of ascertaining the existence, location, extent or quality of any deposit of ore or other mineral, and paid or incurred before the beginning of the development stage of the mine or deposit. The term development expenditures means expenditures paid or incurred during the development stage of a mine or other natural deposits. The development stage of a mine or other natural deposit shall begin at the time when deposit of ore or other minerals is shown to exist in sufficient commercial quantity and quality and shall end upon commencement of actual commercial extraction. 3. Depletion of oil and gas wells and mines deductible by a non-resident alien individual or foreign corporation. In the case of a non-resident alien individual engaged in trade or business in the Philippines or a resident foreign corporation, allowance for depletion of oil and gas wells or mines under paragraph 1 of this subsection shall be authorized only in respect to oil and gas wells or mines located within the Philippines. H. Charitable and other contributions. 1. In general. Contributions or gifts actually paid or made within the taxable year to, or for the use of the government of the Philippines or any of its agencies or any political subdivision thereof exclusively for public purposes, or to accredited domestic corporation or associations organized and operated exclusively for religious, charitable, scientific, youth and sports development, cultural or educational purposes or for the rehabilitation of veterans, or to social welfare institutions, or to non-government organizations, in accordance with rules and regulations promulgated by the Secretary of Finance upon recommendation of the Commissioner. no part of the net income of which inures to the benefit of any private stockholder or individual in an amount not in excess of 10% in the case of an individual, and 5% in the case of a corporation, of the taxpayer's taxable income derived from trade, business or profession as computed without the benefit of this and the following subparagraphs. 2. Contributions deductible in full. Notwithstanding the provisions of the preceding subparagraph, donations to the following institutions or entities shall be deductible in full. A. Donations to the government. Donations to the government of the Philippines or to any of its agencies or political subdivisions, including fully owned government corporations, exclusively to finance, to provide for, or to be used in undertaking priority activities in education, health, youth and sports development, human settlements, science and culture, and in economic development according to a national priority plan determined by the National Economic and Development Authority, NEDA, in consultation with appropriate government agencies, including its regional development councils and private philanthropic persons and institutions, provided that any donation which is made to the government or to any of its agencies or political subdivisions not in accordance with the said annual priority plan shall be subject to the limitations prescribed in paragraph 1 of this subsection. B. Donations to certain foreign institutions or international organizations. Donations to foreign institutions or international organizations which are fully deductible in pursuance of or in compliance with agreements, treaties, or commitments entered into by the government of the Philippines and the foreign institutions or international organizations or in pursuance of special laws. C. Donations to accredited non-government organizations. The term non-government organization means a non-profit domestic corporation. 1. Organized and operated exclusively for scientific, research, educational, character building and youth and sports development, health, social welfare, cultural or charitable purposes, or a combination thereof, no part of the net income of which inures to the benefit of any private individual. 2. Which, not later than the 15th day of the third month after the close of the accredited non-government organization's taxable year in which contributions are received, makes utilization directly for the active conduct of the activities constituting the purpose or function for which it is organized and operated, unless an extended period is granted by the Secretary of Finance in accordance with the rules and regulations to be promulgated, upon recommendation of the Commissioner. 3. The level of administrative expense of which shall, on an annual basis, conform with the rules and regulations to be prescribed by the Secretary of Finance, upon recommendation of the Commissioner, but in no case to exceed 30% of the total expenses, and 4. The assets of which, in the event of dissolution, would be distributed to another non-profit domestic corporation organized for similar purpose or purposes, or to the state for public purpose, or would be distributed by a court to another organization to be used in such manner as in the judgment of said court shall best accomplish the general purpose for which the dissolved organization was organized, subject to such terms and conditions as may be prescribed by the Secretary of Finance. The term utilization means any amount in cash or in kind, including administrative expenses paid or utilized to accomplish one or more purposes for which the accredited non-government organization was created or organized. Any amount paid to acquire an asset used or held for use directly in carrying out one or more purposes for which the accredited non-government organization was created or organized. An amount set aside for a specific project which comes within one or more purposes of the accredited non-government organization may be treated as a utilization, but only if at the time such amount is set aside the accredited non-government organization has established to the satisfaction of the Commissioner that the amount will be paid for the specific project within a period to be prescribed in rules and regulations to be promulgated by the Secretary of Finance upon recommendation of the Commissioner, but not to exceed 5 years. And the project is one which can be better accomplished by setting aside such amount than by immediate payment of funds. 3. Valuation. The amount of any charitable contribution of property other than money shall be based on the acquisition cost of said property. 4. Proof of deductions. Contributions or gifts shall be allowable as deductions only if verified under the rules and regulations prescribed by the Secretary of Finance upon recommendation of the Commissioner. Research and development. 1. In general, a taxpayer may treat research or development expenditures which are paid or incurred by him during the taxable year in connection with his trade, business or profession as ordinary and necessary expenses which are not chargeable to capital account. The expenditures so treated shall be allowed as deduction during the taxable year when paid or incurred. 2. Amortization of certain research and development expenditures. At the election of the taxpayer and in accordance with the rules and regulations to be prescribed by the Secretary of Finance upon recommendation of the Commissioner. The following research and development expenditures may be treated as deferred expenses. A. Paid or incurred by the taxpayer in connection with his trade, business or profession. B. Not treated as expenses under paragraph 1 hereof and C. Chargeable to capital account but not chargeable to property of a character which is subject to depreciation or depletion. In computing taxable income, such deferred expenses shall be allowed as deduction ratably distributed over a period of not less than 60 months as may be elected by the taxpayer, beginning with the month in which the taxpayer first realizes benefits from such expenditures. The election provided by paragraph 2 hereof may be made for any taxable year beginning after the effectivity of this code, but only if made not later than the time prescribed by law for filing the return for such taxable year. The methods are elected, and the period selected by the taxpayer shall be adhered to in computing taxable income for the taxable year for which the election is made and for all subsequent taxable years unless with the approval of the Commissioner. A change to a different method is authorized with respect to a part or all of such expenditures. The election shall not apply to any expenditure paid or incurred during any taxable year for which the taxpayer makes the election. 3. Limitations on deduction. This subsection shall not apply to A. Any expenditure for the acquisition or improvement of land, or for the improvement of property to be used in connection with research and development of a character which is subject to depreciation and depletion, and B. Any expenditure paid or incurred for the purpose of ascertaining the existence, location, extent, or quality of any deposit of ore or other mineral, including oil or gas. J. Pension trusts. An employer establishing or maintaining a pension trust to provide for the payment of reasonable pensions to his employees shall be allowed as a deduction, in addition to the contributions to such trust during the taxable year to cover the pension liability accruing during the year. Allowed as a deduction under subsection A(1) of this section, a reasonable amount transferred or paid into such trust during the taxable year in excess of such contributions. But only if such amount 1 has not theretofore been allowed as a deduction, and 2 is apportioned in equal parts over a period of 10 consecutive years beginning with the year in which the transfer or payment is made. K. Additional requirements for deductibility of certain payments. Any amount paid or payable which is otherwise deductible from or taken into account in computing gross income or for which depreciation or amortization may be allowed under this section shall be allowed as a deduction only if it is shown that the tax required to be deducted and withheld therefrom has been paid to the Bureau of Internal Revenue in accordance with this section 58 and 81 of this code. L. Optional standard deduction, OSD. In lieu of the deductions allowed under the preceding subsections, an individual subject to tax under section 24, other than a non-resident alien, may elect a standard deduction in an amount not exceeding 40% of his gross sales or gross receipts, as the case may be. In the case of a corporation subject to tax under sections 27A and 28(1), it may elect a standard deduction in an amount not exceeding 40% of its gross income as defined in section 32 of this code. Unless the taxpayer signifies in his return his intention to elect the optional standard deduction, he shall be considered as having availed himself of the deductions allowed in the preceding subsections. Such election when made in the return shall be irrevocable for the taxable year for which the return is made, provided that an individual who is entitled to and claimed for the optional standard deduction shall not be required to submit with his tax return such financial statements otherwise required under this code. Provided, further, that a general professional partnership and the partners comprising such partnership may avail of the optional standard deduction only once, either by the general professional partnership or the partners comprising the partnership, provided, finally, that except when the Commissioner otherwise permits, the said individual shall keep such records pertaining to his gross sales or gross receipts, or the said corporation shall keep such records pertaining to his gross income as defined in section 32 of this code during the taxable year, as may be required by the rules and regulations promulgated by the Secretary of Finance upon recommendation of the Commissioner. Notwithstanding the provision of the preceding subsections, the Secretary of Finance, upon recommendation of the Commissioner, after a public hearing shall have been held for this purpose, may prescribe by rules and regulations, limitations or ceilings for any of the itemized deductions under subsections A(2)(j) of this section, provided that for purposes of determining such ceilings or limitations, the Secretary of Finance shall consider the following factors. 1. Adequacy of the prescribed limits on the actual expenditure requirements of each particular industry, and 2. Effects of inflation on expenditure levels, provided, further, that no ceilings shall further be imposed on items of expense already subject to ceilings under present law. SEC 35. Repealed. SEC 36. Items not deductible. A. General rule. In computing net income, no deduction shall in any case be allowed in respect to 1. Personal, living, or family expenses. 2. Any amount paid out for new buildings or for permanent improvements, or betterments made to increase the value of any property or estate. This subsection shall not apply to intangible drilling and development costs incurred in petroleum operations which are deductible under subsection G(1) of section 34 of this code. 3. Any amount expended in restoring property or in making good the exhaustion thereof for which an allowance is or has been made, or 4. Premiums paid on any life insurance policy covering the life of any officer or employee, or of any person financially interested in any trade or business carried on by the taxpayer. individual or corporate, when the taxpayer is directly or indirectly a beneficiary under such policy. B. Losses from sales or exchanges of property. In computing net income, no deductions shall in any case be allowed in respect of losses from sales or exchanges of property directly or indirectly. 1.
Mga ilan na lang. Dati mga 90% na.
1. Between members of a family. For purposes of this paragraph, the family of an individual shall include only his brothers and sisters, whether by the whole or half-blood, spouse, ancestors, and lineal descendants, or 2. Except in the case of distributions in liquidation, between an individual and corporation more than 50% in value of the outstanding stock of which is owned, directly or indirectly, by or for such individual, or 3. Except in the case of distributions in liquidation, between two corporations more than 50% in value of the outstanding stock of which is owned, directly or indirectly, by or for the same individual if either one of such corporations, with respect to the taxable year of the corporation preceding the date of the sale of exchange, was under the law applicable to such taxable year, a personal holding company or a foreign personal holding company. 4. Between the grantor and a fiduciary of any trust, or 5. Between the fiduciary of and the fiduciary of a trust and the fiduciary of another trust if the same person is a grantor with respect to each trust, or 6. Between a fiduciary of a trust and beneficiary of such trust. SEC 37. Special provisions regarding income and deductions of insurance companies, whether domestic or foreign. A. Special deduction allowed to insurance companies. In the case of insurance companies, whether domestic or foreign doing business in the Philippines, the net additions, if any, required by law to be made in the year to reserve funds and the sums other than dividends paid within the year on policy and annuity contracts may be deducted from the gross income, provided, however, that the released reserve be treated as income for the year of release. B. Mutual insurance companies. In the case of mutual fire and mutual employers' liability and mutual workmen's compensation and mutual casualty insurance companies requiring their members to make premium deposits to provide for losses and expenses, said companies shall not return as income any portion of the premium deposits returned to their policyholders, but shall return as taxable income all income received by them from all other sources plus such portion of the premium deposits as are retained by the companies for purposes other than the payment of losses and expenses and reinsurance reserves. C. Mutual marine insurance companies. Mutual marine insurance companies shall include in their return of gross income gross premiums collected and received by them less amounts paid to policyholders on account of premiums previously paid by them and interest paid upon those amounts between the ascertainment and payment thereof. D. Assessment insurance companies. Assessment insurance companies, whether domestic or foreign, may deduct from their gross income the actual depositive sums with the officers of the government of the Philippines pursuant to law, as additions to guarantee or reserve funds. SEC 38. Losses from wash sales of stock or securities. A. In the case of any loss claimed to have been sustained from any sale or other disposition of shares of stock or securities where it appears that within a period beginning 30 days before the date of such sale or disposition and ending 30 days after such date, the taxpayer has acquired by purchase or by exchange upon which the entire amount of gain or loss was recognized by law, or has entered into a contract or option so to acquire substantially identical stock or securities. Then no deduction for the loss shall be allowed under Section 34 unless the claim is made by a dealer in stock or securities and with respect to a transaction made in the ordinary course of the business of such dealer. B. If the amount of stock or securities acquired or covered by the contract or option to acquire is less than the amount of stock or securities sold or otherwise disposed of, then the particular shares of stock or securities, the loss from the sale or other disposition of which is not deductible, shall be determined under rules and regulations prescribed by the Secretary of Finance upon recommendation of the Commissioner. C. If the amount of stock or securities acquired or covered by the contract or option to acquire which is not less than the amount of stock or securities sold or otherwise disposed of, then the particular shares of stock or securities, the acquisition of which or the contract or option to acquire which resulted in the non-deductibility of the loss shall be determined under rules and regulations prescribed by the Secretary of Finance upon recommendation of the Commissioner. SEC 39. Capital gains and losses. A. Definitions. Assist in this title. 1. Capital assets. The term capital assets means property held by the taxpayer, whether or not connected with his trade or business, but does not include stock in trade of the taxpayer or other property of the kind which would properly be included in the inventory of the taxpayer if on hand at the close of the taxable year, or property held by the taxpayer primarily for sale to customers in the ordinary course of his trade or business, or property used in the trade or business of a character which is subject to the allowance for depreciation provided in subsection F of section 34, or real property used in trade or business of the taxpayer. 2. Net capital gain. The term net capital gain means the excess of the gains from sales or exchanges of capital assets over the losses from such sales or exchanges. 3. Net capital loss. The term net capital loss means the excess of the losses from sales or exchanges of capital assets over the gains from such sales or exchanges. B. Percentage taken into account in the case of a taxpayer other than a corporation. Only the following percentages of a gain or loss recognized upon the sale or exchange of a capital asset shall be taken into account in computing net capital gain, net capital loss, and net income. 1. 100% if the capital asset has been held for not more than 12 months, and 2. 50% if the capital asset has been held for more than 12 months. C. Limitation on capital losses. Losses from sales or exchange capital assets shall be allowed only to the extent of the gains from such sales or exchanges. If a bank or trust company incorporated under the laws of the Philippines, a substantial part of whose business is the receipt of deposits, sells any bond, debenture, note, or certificate or other evidence of indebtedness issued by any corporation, including one issued by a government or political subdivision thereof, with interest coupons or in registered form, any loss resulting from such sale shall not be subject to the foregoing limitation and shall not be included in determining the applicability of such limitation to other losses. D. Net capital loss carryover. If any taxpayer, other than a corporation, sustains in any taxable year a net capital loss, such loss in an amount not in excess of the net income for such year shall be treated in the succeeding taxable year as a loss from the sale or exchange of a capital asset held for not more than 12 months. E. Retirement of bonds, etc. For purposes of this title, amounts received by the holder upon the retirement of bonds, debentures, notes or certificates or other evidences of indebtedness issued by any corporation, including those issued by a government or political subdivision thereof, with interest coupons or in registered form, shall be considered as amounts received in exchange therefor. F. Gains or losses from short sales, etc. For purposes of this title. 1. Gains or losses from short sales of property shall be considered as gains or losses from sales or exchanges of capital assets, and 2. Gains or losses attributable to the failure to exercise privileges or options to buy or sell property shall be considered as capital gains or losses. SEC 40. Determination of amount and recognition of gain or loss. A. Computation of gain or loss. The gain from the sale or other disposition of property shall be the excess of the amount realized therefrom over the basis or adjusted basis for determining gain, and the loss shall be the excess of the basis or adjusted basis for determining loss over the amount realized. The amount realized from the sale or other disposition of property shall be the sum of money received plus the fair market value of the property other than money received. B. Basis for determining gain or loss from sale or disposition of property. The basis of property shall be 1. The cost thereof in the case of property acquired on or after March 1, 1913, if such property was acquired by purchase, or 2. The fair market price or value as of the date of acquisition, if the same was acquired by inheritance, or 3. If the property was acquired by gift, the basis shall be the same as if it would be in the hands of the donor or the last preceding owner by whom it was not acquired by gift, except that if such basis is greater than the fair market value of the property at the time of the gift, then, for the purpose of determining loss, the basis shall be such fair market value, or 4. If the property was acquired for less than an adequate consideration in money or money's worth, the basis of such property is the amount paid by the transferee for the property, or 5. The basis as defined in paragraph C5 of this section, if the property was acquired in a transaction where gain or loss is not recognized under paragraph C2 of this section. C. Exchange of property. 1. General rule. Except as herein provided, upon the sale or exchange or property, the entire amount of the gain or loss, as the case may be, shall be recognized. 2. Exception. No gain or loss shall be recognized on a corporation or on its stock or securities if such corporation is a party to a reorganization and exchanges property in pursuance of a plan of reorganization, solely for stock or securities in another corporation that is a party to the reorganization. A reorganization is defined as A corporation, which is a party to a merger or consolidation, exchanges property solely for stock in a corporation, which is a party to the merger or consolidation, or B. The acquisition by one corporation, in exchange solely for all or a part of its voting stock. or in exchange solely for all or part of the voting stock of a corporation which is in control of the acquiring corporation, the stock of another corporation if immediately after the acquisition the acquiring corporation has control of such other corporation whether or not such acquiring corporation had control immediately before the acquisition, or c. the acquisition by one corporation in exchange solely for all or a part of its voting stock, or in exchange solely for all or part of the voting stock of a corporation which is in control of the acquiring corporation of substantially all of the properties of another corporation. In determining whether the exchange is solely for stock, the assumption by the acquiring corporation of a liability of the others shall be disregarded, or d. a recapitalization, which shall mean an arrangement whereby the stock and bonds of a corporation are readjusted as to amount, income, or priority, or an agreement of all stockholders and creditors to change and increase or decrease the capitalization or debts of the corporation, or both, or e. a reincorporation, which shall mean the formation of the same corporate business with the same assets and the same stockholders surviving under a new charter. No gain or loss shall also be recognized if property is transferred to a corporation by a person, alone or together with others, not exceeding four persons, in exchange for stock or unit of participation in such a corporation of which as a result of such exchange the transferor or transferors collectively gains or maintains control of said corporation, provided that stocks issued for services shall not be considered as issued in return for property. Sale or exchanges of property used for business for shares of stock covered under this subsection shall not be subject to value-added tax. In all of the foregoing instances of exchange of property, prior Bureau of Internal Revenue confirmation or tax ruling shall not be required for purposes of availing the tax exemption. 3. Exchange not solely in kind. A. If in connection with an exchange described in the above exceptions, an individual, a shareholder, a security holder or a corporation receives not only stock or securities permitted to be received without the recognition of gain or loss but also money and or property, the gain, if any, but not the loss, shall be recognized but in an amount not in excess of the sum of the money and fair market value of such other property received, provided that as to the shareholder, if the money and or other property received has the effect of a distribution of a taxable dividend, there shall be taxed as dividend to the shareholder an amount of the gain recognized not in excess of his proportionate share of the undistributed earnings and profits of the corporation. The remainder, if any, of the gain recognized shall be treated as a capital gain. B. If in connection with the exchange described in the above exceptions, the transferor corporation receives not only stock permitted to be received without the recognition of gain or loss but also money and or other property, then, if the corporation receiving such money and or other property distributes it in pursuance of the plan of merger or consolidation, no gain to the corporation shall be recognized from the exchange. But if the corporation receiving such other property and or money does not distribute it in pursuance of the plan of merger or consolidation, the gain, if any, but not the loss to the corporation shall be recognized but in an amount not in excess of the sum of such money and the fair market value of such other property so received which is not distributed. 4. Assumption of liability. A. If the taxpayer, in connection with the exchanges described in the foregoing exceptions, receives stock or securities which would be permitted to be received without the recognition of the gain if it were the sole consideration and as part of the consideration, another party to the exchange assumes the liability of the taxpayer or acquires from the taxpayer property subject to a liability, then such assumption or acquisition shall not be treated as money or other property and shall not prevent the exchange from being within the exceptions. B. If the amount of the liabilities assumed plus the amount of the liabilities to which the property is subject exceed the total of the adjusted basis of the property transferred pursuant to such exchange, then such excess shall be considered as a gain from the sale or exchange of a capital asset or of property which is not a capital asset, as the case may be. 5. Basis. A. The basis of the stock or securities received by the transferor upon the exchange specified in the above exceptions shall be the same as the basis of the property, stock or securities exchanged, decreased by 1. The money received, and 2. The fair market value of the other property received, and increased by the amount treated as dividend of the shareholder, and b. The amount of any gain that was recognized on the exchange, provided that the property received as boot shall have as basis its fair market value, provided, further, that if as part of the consideration to the transferor, the transferee of property assumes a liability of the transferor or acquires from the latter property subject to a liability, such assumption or acquisition, in the amount of the liability, shall, for purposes of this paragraph, be treated as money received by the transferor on the exchange, provided, finally, that if the transferor receives several kinds of stock or securities, the Commissioner is hereby authorized to allocate the basis among the several classes of stocks or securities. B. The basis of the property transferred in the hands of the transferee shall be the same as it would be in the hands of the transferor, increased by the amount of the gain recognized to the transferor on the transfer. 6. Definitions. A. The term securities means bonds and debentures but not notes of whatever class or duration. B. The term merger or consolidation, when used in this section, shall be understood to mean I. The ordinary merger or consolidation. Or E. The acquisition by one corporation of all or substantially all the properties of another corporation solely for stock, provided that for a transaction to be regarded as a merger or consolidation within the purview of this section, it must be undertaken for a bona fide business purpose and not solely for the purpose of escaping the burden of taxation, provided, further, that in determining whether a bona fide business purpose exists, each and every step of the transaction shall be considered and the whole transaction or series of transactions shall be treated as a single unit, provided, finally, that in determining whether the property transferred constitutes a substantial portion of the property of the transferor, the term property shall be taken to include the cash assets of the transferor. C. The term control, when used in this section, shall mean ownership of stocks in a corporation after the transfer of property possessing at least 51% of the total voting power of all classes of stocks entitled to vote, provided that the collective and not the individual ownership of all classes of stocks entitled to vote of the transferor or transferors under this section shall be used in determining the presence of control. D. The Secretary of Finance, upon recommendation of the Commissioner, is hereby authorized to issue rules and regulations for the purpose, substantially all, and for the proper implementation of this section. SEC 41. Inventories. Whenever in the judgment of the Commissioner, the use of inventories is necessary in order to determine clearly the income of any taxpayer, inventories shall be taken by such taxpayer upon such basis as the Secretary of Finance, upon recommendation of the Commissioner, may, by rules and regulations, prescribe as conforming as nearly as may be to the best accounting practice in the trade or business and as most clearly reflecting the income. If a taxpayer, after having complied with the terms and conditions prescribed by the Commissioner, uses a particular method of valuing its inventory for any taxable year, then such method shall be used in all subsequent taxable years unless I, with the approval of the Commissioner, a change to a different method is authorized, or E. The Commissioner finds that the nature of the stock on hand, e.g., its scarcity, liquidity, marketability and price movements, is such that inventory gains should be considered realized for tax purposes and, therefore, it is necessary to modify the valuation method for purposes of ascertaining the income, profits, or loss in a more realistic manner, provided, however, that the Commissioner shall not exercise his authority to require a change in inventory method more often than once every 3 years, provided, further, that any change in an inventory valuation method must be subject to approval by the Secretary of Finance. SEC 42. Income from sources within the Philippines. A. Gross income from sources within the Philippines. The following items of gross income shall be treated as gross income from sources within the Philippines. 1. Interests. Interest derived from sources within the Philippines, and interests on bonds, notes or other interest-bearing obligation of residents, corporate or otherwise. 2. Dividends. The amount received as dividends. A. From a domestic corporation and B. From a foreign corporation, unless less than 50% of the gross income of such foreign corporation for the 3-year period ending with the close of its taxable year preceding the declaration of such dividends, or for such part of such period as the corporation has been in existence was derived from sources within the Philippines as determined under the provisions of this section, but only in an amount which bears the same ratio to such dividends as the gross income of the corporation for such period derived from sources within the Philippines bears to its gross income from all sources. 3. Services. Compensation for labor or personal services performed in the Philippines. 4. Rentals and royalties. Rentals and royalties from property located in the Philippines or from any interest in such property, including rentals or royalties for A. The use of or the right or privilege to use in the Philippines any copyright, patent, design or model, plan, secret formula or process, goodwill, trademark, trade brand or other like property or right. B. The use of or the right to use in the Philippines any industrial, commercial or scientific equipment. C. The supply of scientific, technical, industrial or commercial knowledge or information. D. The supply of any assistance that is ancillary and subsidiary to, and is furnished as a means of enabling the application or enjoyment of any such property or right as is mentioned in paragraph A, any such equipment as is mentioned in paragraph B, or any such knowledge or information as is mentioned in paragraph C. E. The supply of services by a non-resident person or his employee in connection with the use of property or rights belonging to or the installation or operation of any brand, machinery or other apparatus purchased from such non-resident person. F. Technical advice, assistance or services rendered in connection with technical management or administration of any scientific, industrial or commercial undertaking, venture, project or scheme, and G. The use of or the right to use I. Motion picture films, E. Films or videotapes for use in connection with television, and E. Tapes for use in connection with radio broadcasting. 5. Sale of real property. Gains, profits and income from the sale of real property located in the Philippines, and 6. Sale of personal property. Gains, profits and income from the sale of personal property, as determined in subsection E of this section. B. Taxable income from sources within the Philippines. 1. General rule. From the items of gross income specified in subsection A of this section, there shall be deducted the expenses, losses and other deductions properly allocated thereto, and a rateable part of expenses, interests, losses and other deductions effectively connected with the business or trade conducted exclusively within the Philippines, which cannot definitely be allocated to some items or class of gross income, provided that such items of deduction shall be allowed only if fully substantiated by all the information necessary for its calculation. The remainder, if any, shall be treated in full as taxable income from sources within the Philippines. 2. Exception. No deductions for interest paid or incurred abroad shall be allowed from the item of gross income specified in subsection A, unless indebtedness was actually incurred to provide funds for use in connection with the conduct or operation of trade or business in the Philippines. C. Gross income from sources without the Philippines. The following items of gross income shall be treated as income from sources without the Philippines. 1. Interests other than those derived from sources within the Philippines as provided in paragraph 1 of subsection of this section. 2. Dividends other than those derived from sources within the Philippines as provided in paragraph 2 of subsection of this section. 3. Compensation for labor or personal services performed without the Philippines. 4. Rentals or royalties from property located without the Philippines or from any interest in such property, including rentals or royalties for the use of or for the privilege of using without their Philippines patents, copyrights, secret processes and formulas, goodwill, trademarks, trade brand, franchises and other like properties, and 5. Gains, profits and income from the sale of real property located without the Philippines. D. Taxable income from sources without the Philippines. From the items of gross income specified in subsection C of this section, there shall be deducted the expenses, losses, and other deductions properly apportioned or allocated thereto, and a rateable part of any expense, loss or other deduction which cannot definitely be allocated to some items or classes of gross income. The remainder, if any, shall be treated in full as taxable income from sources without the Philippines. E. Income from sources partly within and partly without the Philippines, items of gross income, expenses, losses and deductions other than those specified in subsections A and C of this section, shall be allocated or apportioned to sources within or without the Philippines, under the rules and regulations prescribed by the Secretary of Finance, upon recommendation of the Commissioner. Where items of gross income are separately allocated to sources within the Philippines, there shall be deducted, for the purpose of computing the taxable income therefrom, the expenses, losses and other deductions properly apportioned or allocated thereto, and a rateable part of other expenses, losses or other deductions which cannot definitely be allocated to some items or classes of gross income. The remainder, if any, shall be included in full as taxable income from sources within the Philippines. In the case of gross income derived from sources partly within and partly without the Philippines, the taxable income may first be computed by deducting the expenses, losses or other deductions apportioned or allocated thereto, and a rateable part of any expense, loss or other deduction which cannot definitely be allocated to some items or classes of gross income. And the portion of such taxable income attributable to sources within the Philippines may be determined by processes or formulas of general apportionment prescribed by the Secretary of Finance. Gains, profits and income from the sale of personal property produced in whole or in part by the taxpayer within and sold without the Philippines, or produced in whole or in part by the taxpayer without and sold within the Philippines, shall be treated as derived partly from sources within and partly from sources without the Philippines. Gains, profits and income derived from the purchase of personal property within and its sale without the Philippines, or from the purchase of personal property without and its sale within the Philippines, shall be treated as derived entirely from sources within the country in which sold, provided, however, that gain from the sale of shares of stock in a domestic corporation shall be treated as derived entirely from sources within the Philippines, regardless of where the said shares are sold. The transfer by a non-resident alien or a foreign corporation to anyone of any share of stock issued by a domestic corporation shall not be effected or made in its book unless 1. The transferor has filed with the Commissioner a bond conditioned upon the future payment by him of any income tax that may be due on the gains derived from such transfer. Or 2. The Commissioner has certified that the taxes, if any, imposed in this title and due on the gain realized from such sale or transfer have been paid. It shall be the duty of the transferor and the corporation the shares of which are sold or transferred to advise the transferee of this requirement. F. Definitions. Assist in this section the words sale or sold include exchange or exchanged, and the words produced includes created, fabricated, manufactured, extracted, processed, cured, or aged. Chapter 8. Accounting periods and methods of accounting. SEC 43. General rule. The taxable income shall be computed upon the basis of the taxpayer's annual accounting period, fiscal year or calendar year, as the case may be, in accordance with the method of accounting regularly employed in keeping the books of such taxpayer, but if no such method of accounting has been so employed, or if the method employed does not clearly reflect the income, the computation shall be made in accordance with such method as in the opinion of the Commissioner clearly reflects the income. If the taxpayer's annual accounting period is other than a fiscal year, as defined in Section 22Q, or if the taxpayer has no annual accounting period, or does not keep books, or if the taxpayer is an individual, the taxable income shall be computed on the basis of the calendar year. SEC 44. Period in which items of gross income included. The amount of all items of gross income shall be included in the gross income for the taxable year in which received by the taxpayer, unless, under methods of accounting permitted under Section 43, any such amounts are to be properly accounted for as of a different period. In the case of the death of a taxpayer, there shall be included in computing taxable income for the taxable period in which falls the date of his death amounts accrued up to the date of his death if not otherwise properly includable in respect of such period or a prior period. SEC 45. Period for which deductions and credits taken. The deductions provided for in this title shall be taken for the taxable year in which paid or accrued, or paid or incurred, dependent upon the method of accounting upon the basis of which the net income is computed, unless in order to clearly reflect the income, the deductions should be taken as of a different period. In the case of the death of a taxpayer, there shall be allowed as deductions for the taxable period in which falls the date of his death amounts accrued up to the date of his death if not otherwise properly allowable in respect of such period or a prior period. SEC 46. Change of accounting period. If a taxpayer, other than an individual, changes his accounting period from fiscal year to calendar year, from calendar year to fiscal year, or from one fiscal year to another, the net income shall, with the approval of the Commissioner, be computed on the basis of such new accounting period, subject to the provisions of Section 47. SEC 47. Final or adjustment returns for a period of less than 12 months. A. Returns for short period A resulting from change of accounting period. If a taxpayer, other than an individual, with the approval of the Commissioner, changes the basis of computing net income from fiscal year to calendar year, a separate final or adjustment return shall be made for the period between the close of the last fiscal year for which return was made and the following December 31st. If the change is from calendar year to fiscal year, a separate final or adjustment return shall be made for the period between the close of the last calendar year for which return was made and the date designated as the close of the fiscal year. If the change is from one fiscal year to another fiscal year, a separate final or adjustment return shall be made for the period between the close of the former fiscal year and the date designated as the close of the new fiscal year. B. Income computed on basis of short period. Where a separate final or adjustment return is made under subsection on account of a change in the accounting period, and in all other cases where a separate final or adjustment return is required or permitted by rules and regulations prescribed by the Secretary of Finance upon recommendation of the Commissioner, to be made for a fractional part of a year, then the income shall be computed on the basis of the period for which separate final or adjustment return is made. SEC 48. Accounting for long-term contracts. Income from long-term contracts shall be reported for tax purposes in the manner as provided in this section. As used herein, the term long-term contracts means building, installation or construction contracts covering a period in excess of one year. Persons whose gross income is derived in whole or in part from such contracts shall report such income upon the basis of percentage of completion. The return should be accompanied by a return certificate of architects or engineers showing the percentage of completion during the taxable year of the entire work performed under contract. There should be deducted from such gross income all expenditures made during the taxable year on account of the contract. Account being taken of the material and supplies on hand at the beginning and end of the taxable period for use in connection with the work under the contract but not yet so applied. If upon completion of a contract, it is found that the taxable net income arising thereunder has not been clearly reflected for any year or years, the Commissioner may permit or require an amended return. SEC 49. Installment basis. A. Sales of dealers in personal property. Under rules and regulations prescribed by the Secretary of Finance upon recommendation of the Commissioner, a person who regularly sells or otherwise disposes of personal property on the installment plan may return as income therefrom in any taxable year the proportion of the installment payments actually received in that year, which the gross profit realized or to be realized when payment is completed bears to the total contract price. B. Sales of realty and casual sales of personality. In the case 1 of a casual sale or other casual disposition of personal property other than property of a kind which would properly be included in the inventory of the taxpayer if on hand at their close of the taxable year, for a price exceeding 1,000 pesos P 1,000, or 2, the sale or other disposition of real property. If in either case the initial payments do not exceed 25% of the selling price, the income may, under the rules and regulations prescribed by the Secretary of Finance, upon recommendation of the Commissioner, be returned on the basis and in a manner above prescribed in this section. As used in this section, the term initial payments means the payments received in cash or property other than evidences of indebtedness of the purchaser during the taxable period in which the sale or other disposition is made. C. Sales of real property considered as capital asset by individuals. An individual who sells or disposes of real property considered as capital asset and is otherwise qualified to report the gain therefrom under subsection B may pay the capital gains tax in installments under rules and regulations to be promulgated by the Secretary of Finance upon recommendation of the Commissioner. D. Change from accrual to installment basis. IFA taxpayer entitled to the benefits of subsection A elects for any taxable year to report his taxable income on the installment basis, then in computing his income for the year of change or any subsequent year. Amounts actually received during any such year on account of sales or other dispositions of property made in any prior year shall not be excluded. SEC 50. Allocation of income and deductions. In the case of two or more organizations, trades or businesses, whether or not incorporated and whether or not organized in the Philippines, owned or controlled directly or indirectly by the same interests, the Commissioner is authorized to distribute, apportion or allocate gross income or deductions between or among such organization, trade or business, if he determined that such distribution, apportionment or allocation is necessary in order to prevent evasion of taxes or clearly to reflect the income of any such organization, trade or business. Chapter IX. Returns and payment of tax. SEC 51. Individual return. A. Requirements. 1. Except as provided in paragraph 2 of this subsection, the following individuals are required to file an income tax return. A. Every Filipino citizen residing in the Philippines. B. Every Filipino citizen residing outside the Philippines, on his income from sources within the Philippines. C. Every alien residing in the Philippines, on income derived from sources within the Philippines, and D. Every non-resident alien engaged in trade or business or in the exercise of profession in the Philippines. 2. The following individuals shall not be required to file an income tax return. A. An individual whose taxable income does not exceed 250,000 pesos p. 250,000 and under Section 24, 2, provided that a citizen of the Philippines and any alien individual engaged in business or practice of profession within the Philippines shall file an income tax return, regardless of the amount of gross income. B. An individual with respect to pure compensation income, as defined in Section 32(a)(1), derived from sources within the Philippines, the income tax on which has been correctly withheld under the provisions of Section 79 of this Code, provided that an individual deriving compensation concurrently from two or more employers at any time during the taxable year shall file an income tax return. C. An individual whose sole income has been subjected to final withholding tax pursuant to Section 57(a) of this Code, and D. A minimum wage earner as defined in Section 22(h) of this Code, or an individual who is exempt from income tax pursuant to the provisions of this Code and other laws, general or special. 3. The foregoing notwithstanding, any individual not required to file an income tax return may nevertheless be required to file an information return pursuant to rules and regulations prescribed by the Secretary of Finance, upon recommendation of the Commissioner. 4. The income tax return shall be filed in duplicate by the following persons. A. A resident citizen on his income from all sources. B. A non-resident citizen on his income derived from sources within the Philippines. C. A resident alien on his income derived from sources within the Philippines, and D. A non-resident alien engaged in trade or business in the Philippines on his income derived from sources within the Philippines. 5. The income tax return (ITR) shall consist of a maximum of 4 pages in paper form or electronic form, and shall only contain the following information. A. Personal profile and information. B. Total gross sales, receipts or income from compensation for services rendered, conduct of trade or business or the exercise of profession, except income subject to final taxes provided under this Code. C. Allowable deductions under this Code. D. Taxable income as defined in Section 31 of this Code, and E. Income tax due and payable. B. Where to file. Except in cases where the Commissioner otherwise permits, the return shall be filed with an authorized agent, bank, revenue district officer, collection agent or duly authorized treasurer of the city or municipality in which such person has his legal residence or principal place of business in the Philippines. Or if there be no legal residence or place of business in the Philippines, with the office of a Commissioner. C. When to file. 1. The return of any individual specified above shall be filed on or before the 15th day of April of each year covering income for the preceding taxable year. 2. Individuals subject to tax on capital gains. A. From the sale or exchange of shares of stock not traded through a local stock exchange as prescribed under Section 24, C. Shall file a return within 30 days after each transaction and a final consolidated return on or before April 15th of each year covering all stock transactions of the preceding taxable year, and B. From the sale or disposition of real property under Section 24, D. Shall file a return within 30 days following each sale or other disposition. D. Husband and wife. Married individuals, whether citizens, resident or non-resident aliens, who do not derive income purely from compensation, shall file a return for the taxable year to include the income of both spouses, but where it is impracticable for the spouses to file one return, each spouse may file a separate return of income, but the returns so filed shall be consolidated by the Bureau for purposes of verification for the taxable year. E. Return of parent to include income of children. The income of unmarried minors derived from property received from a living parent shall be included in the return of the parent, except 1. When the donor's tax has been paid on such property, or 2. When the transfer of such property is exempt from donor's tax. F. Persons under disability. If the taxpayer is unable to make his own return, the return may be made by his duly authorized agent or representative or by the guardian or other person charged with the care of his person or property. The principal and his representative or guardian assuming the responsibility of making the return and incurring penalties provided for erroneous, false or fraudulent returns. G. Signature presumed correct. The fact that an individual's name is signed to a filed return shall be prima facie evidence for all purposes that the return was actually signed by him. SEC 51A. Substituted filing of income tax returns by employees receiving purely compensation income. Individual taxpayers receiving purely compensation income, regardless of amount, from only one employer in the Philippines for the calendar year, the income tax of which has been withheld correctly by the said employer, tax due equals tax withheld, shall not be required to file an annual income tax return. The certificate of withholding filed by the respective employers, duly stamped, received by the BER, shall be tantamount to the substituted filing of income tax returns by said employees. SEC 52. Corporation returns. A. Requirements. Every corporation subject to the tax herein imposed, except foreign corporations not engaged in trade or business in the Philippines, shall render, in duplicate, a true and accurate quarterly income tax return and final or adjustment return in accordance with the provisions of Chapter 12 of this title. The income tax return shall consist of a maximum of 4 pages in paper form or electronic form, be filed by the President, Vice President or other principal officer, and shall be sworn to by such officer and by the Treasurer or Assistant Treasurer, and shall only contain the following information. 1. Corporate profile and information. 2. Gross sales, receipts or income from services rendered, conduct of trade or business, except income subject to final taxes provided under this code. 3. Allowable deductions under this code. 4. Taxable income as defined in Section 31 of this code, and 5. Income tax due and payable, provided that the foregoing provisions shall not affect the implementation of Republic Act 10708 or TIMTA. B. Taxable year of corporation. A corporation may employ either calendar year or fiscal year as a basis for filing its annual income tax return, provided that the corporation shall not change the accounting period employed without prior approval from the Commissioner in accordance with the provisions of Section 47 of this code. C. Return of corporation contemplating dissolution or reorganization. Every corporation shall, within 30 days after the adoption by the corporation of a resolution or plan for its dissolution, or for the liquidation of the whole or any part of its capital stock, including a corporation which has been notified of possible involuntary dissolution by the Securities and Exchange Commission, or for its reorganization, render a correct return to the Commissioner, verified under oath, setting forth the terms of such resolution or plan and such other information as the Secretary of Finance, upon recommendation of the Commissioner, shall, by rules and regulations, prescribe. The dissolving or reorganizing corporation shall, prior to the issuance by the Securities and Exchange Commission of the Certificate of Dissolution or Reorganization, as may be defined by rules and regulations prescribed by the Secretary of Finance, upon recommendation of the Commissioner, secure a certificate of tax clearance from the Bureau of Internal Revenue, which certificates shall be submitted to the Securities and Exchange Commission. D. Return on capital gains realized from sale of shares of stock not traded in a local stock exchange. Every corporation deriving capital gains from the sale or exchange of shares of stock not traded through a local stock exchange as prescribed under Sections 24C, 25A3, 27E2, 28A8C, and 28B5C shall file a return within 30 days after each transactions and a final consolidated return of all transactions during the taxable year on or before the 15th day of the fourth month following the close of the taxable year. SEC 53. Extension of time to file returns. The Commissioner may, in meritorious cases, grant a reasonable extension of time for filing returns of income or final and adjustment returns in case of corporations, subject to the provisions of Section 56 of this Code. SEC 54. Returns of receivers, trustees in bankruptcy or assignees. In cases wherein receivers, trustees in bankruptcy or assignees are operating the property or business of a corporation, subject to the tax imposed by this title, such receivers, trustees or assignees shall make returns of net income as and for such corporation, in the same manner and form as such organization is hereinbefore required to make returns, and any tax due on the income as returned by receivers. Trustees or assignees shall be assessed and collected in the same manner as if assessed directly against the organizations of whose businesses or properties they have custody or control. SEC 55. Returns of general professional partnerships. Every general professional partnership shall file, in duplicate, a return of its income, except income exempt under Section 32(b) of this title, setting forth the items of gross income and of deductions allowed by this title, and the names, taxpayer identification numbers, TIN, addresses and shares of each of the partners. SEC 56. Payment and assessment of income tax for individuals and corporations. A. Payment of tax. 1. In general. The total amount of tax imposed by this title shall be paid by the person subject thereto at the time the return is filed. In the case of tramp vessels, the shipping agents and/or the husbanding agent, and in their absence, the captains thereof are required to file the return herein provided and pay the tax due thereon before their departure. Upon failure of the said agents or captains to file the return and pay the tax, the Bureau of Customs is hereby authorized to hold the vessel and prevent its departure until proof of payment of the tax is presented or a sufficient bond is filed to answer for the tax due. 2. Installment of payment. Fena tax due is in excess of 2,000 pesos p. 2,000 and the taxpayer other than a corporation may elect to pay the tax in two equal installments, in which case the first installment shall be paid at the time the return is filed and the second installment on or before October 15th following the close of the calendar year. If any installment is not paid on or before the date fixed for its payment, the whole amount of the tax unpaid becomes due and payable together with the delinquency penalties. 3. Payment of capital gains tax. The total amount of tax imposed and prescribed under Section 24(c), 24(d), 27(e)(2), 28(8)(c), and 28(b)(5)(c) shall be paid on the date the return prescribed therefore is filed by the person liable thereto, provided that if the seller submits proof of his intention to avail himself of the benefit of exemption of capital gains under existing special laws, no such payments shall be required, provided, further, that in case of failure to qualify for exemption under such special laws and implementing rules and regulations, the tax due on the gains realized from the original transaction shall immediately become due and payable, subject to the penalties prescribed under applicable provisions of this code, provided, finally, that if the seller, having paid the tax, submits such proof of intent within 6 months from the registration of the document transferring the real property, he shall be entitled to a refund of such tax upon verification of his compliance with the requirements for such exemption. In case the taxpayer elects and is qualified to report the gain by installments under Section 49 of this Code, the tax due from each installment payment shall be paid within 30 days from the receipt of such payments. No registration of any document transferring real property shall be effected by the Register of Deeds unless the Commissioner or his duly authorized representative has certified that such transfer has been reported, and the tax herein imposed, if any, has been paid. B. Assessment and payment of deficiency tax. After the return is filed, the Commissioner shall examine it and assess the correct amount of the tax. The tax or deficiency income tax so discovered shall be paid upon notice and demand from the Commissioner. As used in this chapter, in respect of a tax imposed by this title, the term deficiency means 1. The amount by which the tax imposed by this title exceeds the amount shown as the tax by the taxpayer upon his return. But the amount so shown on the return shall be increased by the amounts previously assessed or collected without assessment as a deficiency, and decreased by the amount previously abated, credited, returned or otherwise repaid in respect of such tax, or 2. If no amount is shown as the tax by the taxpayer upon this return, or if no return is made by the taxpayer, then the amount by which the tax exceeds the amounts previously assessed or collected without assessment as a deficiency. But such amounts previously assessed or collected without assessment shall first be decreased by the amounts previously abated, credited, returned or otherwise repaid in respect of such tax. SEC 57. Withholding of tax at source. A. Withholding of final tax on certain incomes. Subject to rules and regulations the Secretary of Finance may promulgate, upon the recommendation of the Commissioner, requiring the filing of income tax return by certain income payees. The tax imposed or prescribed by sections 24b(1), 24b(2), 24c, 24d(1), 25(2), 25(3), 25b, 25c, 25d, 25e, 27d(1), 27d(2), 27d(3), 27d(5), 28(4), 28(5). 28(7), 28(7)b, 28(7)c, 28b(1), 28b(2), 28b(3), 28b(4), 28b(5), 28b(5b), 28b(5c), 33. And 282 of this code on specified items of income shall be withheld by payer corporation and or person and paid in the same manner and subject to the same conditions as provided in section 58 of this code. B. Withholding of creditable tax at source. The Secretary of Finance may, upon the recommendation of the Commissioner, require the withholding of a tax on the items of income payable to natural or juridical persons residing in the Philippines by payer corporation, persons as provided for by law, at the rate of not less than 1%, but not more than 32% thereof, which shall be credited against the income tax liability of the taxpayer for the taxable year, provided that, beginning January 1, 2019, the rate of withholding shall not be less than 1%, but not more than 15% of the income payment. C. Tax-free covenant bonds. In any case where bonds, mortgages, deeds of trust or other similar obligations of domestic or resident foreign corporations contain a contract or provisions by which the obligor agrees to pay any portion of the tax imposed in this title upon the obligee or to reimburse the obligee for any portion of the tax or to pay their interest without deduction for any tax which the obligor may be required or permitted to pay thereon or to retain therefrom under any law of the Philippines, or any state or country. The obligor shall deduct bonds, mortgages, deeds of trust or other obligations, whether the interest or other payments are payable annually or at shorter or longer periods, and whether the bonds, securities or obligations had been or will be issued or marketed, and the interest or other payment thereon paid, within or without the Philippines. If the interest or other payment is payable to a non-resident alien or to a citizen or resident of the Philippines, the Department of Finance shall review, at least once every 3 years, regulations and processes for the withholding of creditable tax under this code, and direct the Bureau of Internal Revenue to amend rules and regulations for the same, should it be found during the review that the existing rules, regulations, and processes for the withholding of creditable tax under this code adversely and materially impact the taxpayer. SEC 58. Returns and payment of taxes withheld at source. A. Quarterly returns and payments of taxes withheld. Taxes deducted and withheld under Section 57 by withholding agents shall be covered by a return and paid to, except in cases where the Commissioner otherwise permits, an authorized agent bank, revenue district officer, collection agent, or duly authorized treasurer of the city or municipality where the withholding agent has his legal residence or principal place of business, or where the withholding agent is a corporation, where the principal office is located. The taxes deducted and withheld by the withholding agent shall be held as a special fund interest for the government until paid to the collecting officers. The return for final and creditable withholding taxes shall be filed in a payment made not later than the last day of the month following the close of the quarter during which withholding was made. B. Statement of income payments made in taxes withheld. Every withholding agent required to deduct and withhold taxes under Section 57 shall furnish each recipient, in respect to his or its receipts during the calendar quarter or year, a written statement showing the income or other payments made by the withholding agent during such quarter or year, and the amount of the tax deducted and withheld therefrom, simultaneously upon payment at the request of the payee, but not later than the 20th day following the close of the quarter in the case of corporate payee, or not later than March 1st of the following year in the case of individual payee for creditable withholding taxes. For final withholding taxes, the statement should be given to the payee on or before January 31st of the succeeding year. See Annual Information Return. Every withholding agent required to deduct and withhold taxes under Section 57 shall submit to the Commissioner an annual information return containing the list of payees and income payments, amount of taxes withheld from each payee and such other pertinent information as may be required by the Commissioner. In the case of final withholding taxes, the return shall be filed on or before January 31st of the succeeding year, and for creditable withholding taxes, not later than March 1st of the year following the year for which the annual report is being submitted. This return, if made and filed in accordance with the rules and regulations approved by the Secretary of Finance upon recommendation of the Commissioner, shall be sufficient compliance with the requirements of Section 68 of this title in respect to the income payments. The Commissioner may, by rules and regulations, grant to any withholding agent a reasonable extension of time to furnish and submit the return required in this subsection. D. Income of recipient. Income upon which any creditable tax is required to be withheld at source under Section 57 shall be included in the return of its recipient, but the excess of the amount of tax so withheld over the Tax due on his return shall be refunded to him subject to the provisions of Section 204. If the income tax collected at source is less than the tax due on his return, the difference shall be paid in accordance with the provisions of Section 56. All taxes withheld pursuant to the provisions of this code and its implementing rules and regulations are hereby considered trust funds and shall be maintained in a separate account and not commingled with any other funds of the withholding agent. E. Registration with Register of Deeds. No registration of any document transferring real property shall be effected by the Register of Deeds unless the Commissioner or his duly authorized representative has certified that such transfer has been reported, and the capital gains or creditable withholding tax, if any, has been paid, provided, however, that the information as may be required by rules and regulations to be prescribed by the Secretary of Finance, upon recommendation of the Commissioner, shall be annotated by the Register of Deeds in the Transfer Certificate of Title or Condominium Certificate of Title, provided, further, that in cases of transfer of property to a corporation, pursuant to a merger, consolidation or reorganization, and where the law allows deferred recognition of income in accordance with Section 40, the information as may be required by rules and regulations to be prescribed by the Secretary of Finance, upon recommendation of the Commissioner, shall be annotated by the Register of Deeds at the back of the Transfer Certificate of Title or Condominium Certificate of Title of the real property involved, provided, finally, that in any violation of this provision by the Register of Deeds shall be subject to the penalties imposed under Section 269 of this Code. SEC 59. Tax on profits collectible from owner or other persons. The tax imposed under this title upon gains, profits, and income not falling under the foregoing and not returned and paid by virtue of the foregoing or as otherwise provided by law shall be assessed by personal return under rules and regulations to be prescribed by the Secretary of Finance, upon recommendation of the Commissioner. The intent and purpose of the title is that all gains, profits and income of a taxable class, as defined in this title, shall be charged and assessed with the corresponding tax prescribed by this title, and said tax shall be paid by the owners of such gains, profits and income, or the proper person having the receipt, custody, control or disposal of the same. For purposes of this title, ownership of such gains, profits and income or liability to pay the tax shall be determined as of the year for which a return is required to be rendered. Chapter X. Estates and Trusts. SEC 60. Imposition of tax. A. Application of tax. The tax imposed by this title upon individuals shall apply to the income of estates or of any kind of property held in trust, including 1. Income accumulated in trust for the benefit of unborn or unascertained person or persons with contingent interests, and income accumulated or held for future distribution under the terms of the will or trust. 2. Income which is to be distributed currently by the fiduciary to the beneficiaries, and income collected by a guardian of an infant which is to be held or distributed as the court may direct. 3. Income received by estates of deceased persons during the period of administration or settlement of the estate, and 4. Income which, in the discretion of the fiduciary, may be either distributed to the beneficiaries or accumulated. B. Exception. The tax imposed by this title shall not apply to employees' trust which forms part of a pension, stock bonus or profit-sharing plan of an employer for the benefit of some or all of his employees. 1. If contributions are made to the trust by such employer or employees, or both for the purpose of distributing to such employees the earnings and principal of the fund accumulated by the trust in accordance with such plan. And 2. If under the trust instrument it is impossible, at any time prior to the satisfaction of all liabilities with respect to employees under the trust, for any part of the corpus or income to be within the tax